Good morning, all. We are here for a hearing in the matter CFI 037, 2017, before His Excellency Justice Omar and Muhairi. The claimant is represented by Clyde & Co. Lead counsel is Joe Wigley. The defendant is represented by KBH Qanun. Lead counsel is Bushra Ahmed.
Yes.
Your Excellency, if I could begin with a little housekeeping, just to check that you have all the materials before you that you should have. The court should have my and my learned friend's skeleton arguments.
Yes.
Together with a bundle of authorities from each of us.
Yeah.
There is also today's hearing bundle, which I think is one bundle of documents, and then hopefully the court should also have the hearing bundle from 29th of January of last year, just which we may refer to probably only to a limited degree.
Yes. The 30th January 2018?
Yes.
Exactly.
Yes, we come.
Your Excellency, the claimant's claim arises out of the share sale and purchase agreement dated the 8th of February 2016, whereby the first and second defendants agreed to sell to the claimant their entire shareholding in the company, third defendant, together with all its assets. Before the court today is the claimant's application dated the 15th of January 2019 for an order pursuant to RDC Rules 18.22, permitting him to re-amend his amended particulars of claim in line with the draft re-amended particulars of claim at tab 6 of the bundle. By way of very brief introduction, initially the claimant sought specific performance of the agreement to secure the transfer of the shareholding in the third defendant, in RAV. I'll refer to the company today as RAV, or the company. The claimant now applies to re-amend his particulars of claim to reflect the fact that he is no longer pursuing that remedy of specific performance in relation to the transfer of the shares. Secondly, to reflect the fact that he has received 3 million dirham deposited to the Dubai courts by the defendants, and to give credit for that receipt. And thirdly, at the same time, he seeks to make good the claim for reimbursement of expenses and losses suffered through the part performance of the share sale and purchase agreement. As one might expect, the share sale and purchase agreement, as we shall see, makes provision on its expressed terms for such repayment in the event that the contract does not proceed to completion. In doing so, in making this application, he also at the same time seeks to take the opportunity to adopt the course suggested by Deputy Chief Justice Steele to review and reformulate the entire particulars of claim, which had been drafted in haste ahead of an urgent ex parte application in August of 2017. So that's the sort of background to the application. It's a very brief summary, and I'll make good those submissions in relation to that. So in those circumstances where, as I will go on to submit, the amended claim is clearly good in law, and as is now clear, is brought under the express provisions of the contract and/or the damages for breach of contract, and as such, there's no question that the IFC court doesn't have jurisdiction, and indeed exclusive jurisdiction, to hear that claim. Also in circumstances where the pleading stage of proceedings have not even yet concluded, with the defendant still not having filed its amended defence in response to the claimant's amended particulars of claim, and indeed no other procedural steps in the claim having taken place. So in those circumstances, it simply can't be said that this application is made at a late stage in the proceedings. And certainly in those circumstances, it's difficult to see the prejudice that my learned friend suggests would be suffered by the defendant that can't be compensated adequately in costs, as indeed the draft order being sought by the claimant makes provision to do so.
But this is not the same application which heard by previous DCJ, Justice Steve. Not exactly same application, and he rejected.
It's not exactly the same at all, as I will explain to you. It's on a very different basis. And indeed, it is following his guidance that he suggests in his decision that this application is brought. But it is, as we'll see from the actual underlying particulars and the draft amended particulars, it's not the same application in any way, not least because the entire particulars of claim have been reformulated and repleaded, but also it's supported now by evidence from both not only the claimant, but also the third party, explaining the basis upon which the 6.8 million, which is the focus, as we'll see today, was advanced to the company or for the benefit of the company. And that's those sums we're seeking repayment of. In those circumstances where it's difficult to see the prejudice being suffered, it is, in my submission, frankly astonishing that the defendant is opposing this application at such great expense, without being able to identify any substantial grounds for doing so, as it should do under the provisions of the rules, other than an attempt to try the claim prematurely at this interlocutory stage, without the benefit of the evidence that you'd expect to have before you at trial, the witness evidence and indeed further disclosure. In particular, my learned friend seeks to take a particular contractual construction of this share sale and purchase agreement, relying on the principles of interpretation, but without the benefit of the evidence which the court would need in order to consider the contract in all the appropriate circumstances, in order to follow the guidance in relation to the construction of the contract that is set out in DIFC law. In those circumstances, it can only be assumed that this is simply an opportunistic attempt by the defendant to unfairly shut out the claimant from bringing what is a substantial claim to seeking repayment of sums advanced to the defendants or for the defendant's benefit, so the company's benefit, and to retain the benefit of those sums unfairly. In terms of a roadmap for where I am going today, I first intend to deal with the relevant background and to deal with the terms of the share sale and purchase agreement before addressing you on a procedural background to demonstrate how this application is different from the previous one heard last year by Deputy Chief Justice Steele. I'll then look at briefly, I don't think there's much between us, on the relevant law to be applied on an application to amend, before then taking you through the draft re-amended particulars of claim and making submissions to the extent I already haven't done so in the course of that elaboration, and dealing briefly with the submissions made by the defendant, although I will say probably my response to a reply, if that's convenient. Just in terms of time today, we had a brief discussion as to how long we might take. Just to clarify how long we thought.
Both planning to lunchtime?
Well, we consider we may spill over. I'm just.
But you have to realize we're discussing only the application, not the whole merits of the case.
Well, I take that point. I'm very happy to curtail my submissions in order that we finish at lunchtime. If that's what.
I mean both.
Yeah.
We'll try to squeeze it until lunchtime, please.
Yes. Very good. We'll take that on board. So before addressing the application in detail, it's worthwhile just summarising the claimant's claim and the nature of the dispute for your Lordship's reference, a summary of which can be found at paragraphs 11 to 18 of my skeleton argument. Now, as mentioned already, the claim arises out of the share sale and purchase agreement of the 8th of February 2016. It's worth turning that up, just so we know what we're talking about. It's at tab 8 of the bundle.
Which bundle?
Oh. Okay,
Your bundle has no
yes, sorry,
tabs.
it's the bundle for today, and it's at page 173.
170?
3. Has Your Excellency had a chance to Have you seen this document?
There's an agreement to me.
Yes, you have seen this document. This is just by way of introduction. I'm just going to take you through it, just so we know what we're talking about. Obviously, we have the recitals reciting the parties on the first page, and then towards the bottom we have the recitals in relation to the ownership of the company, whereas the sellers are the only beneficial de facto owners of 100% of the shares, and at the bottom the agreement to sell, recital describing the agreement to sell 100% of the shares in the company. Turning the page, at clause 1, we have the operative clause, the agreement to sell and purchase the shares and assets. And we see in there, that's set out in clause 1.1, all the assets shall be transferred free of any lien, encumbrance, and all the debts, liabilities, claims, damages, demands of the company shares incurred prior to the 1st of January 2016 shall be the responsibility of the sellers and be deducted by the purchaser from payment fine as desired by the purchaser. I just highlight that because the pivot date throughout this contract, as we see, is the 1st of January 2016. Essentially, prior to that, that's the date at which the for commercial purposes the company is transferred. Prior to that, debts and liabilities are the responsibility of the sellers. After that date, they're the responsibility of the purchaser, assuming that we go to completion. As I'll explain, if we don't go to completion, that's all unravelled. At clause 1.2, there's a clarification in relation to the transfer in relation to the shares. Again, we see a reference to the 31st of December 2015, explaining how, prior to that period, various assets will be assets to the sellers. Again, a reference to the same date as the 31st of December 2015. The purchase price and mechanism for payment is set out at paragraph 2, clause 2, and we'll see there, Your Excellency would have seen reference to this in the skeleton argument. In fact, the date of the entry into the agreement, the first 3 payments, as recorded there, had already been made by the claimant, or at least on his behalf, by Farmers, and obviously that's accepted by the defendants that those payments were made by the claimant. It so happens that they were effected by Farmex on his behalf, and that, as we'll see, is the case with a number of other payments. We'll see that in clause 2.2, where the defendants recognise the receipt of those payments. At 2.2 also, we see the obligation to transfer various assets, and they include the transferring vehicles owned by the company and trademarks owned by the company. At clause 2.3, there is a reference to the receipt of security checks by the purchaser, and these were provided in order to effectively provide security to the purchaser for the sums that they had already paid in the event that the company didn't, the contract didn't proceed to completion. Again, this is a theme running throughout, that the share sale and purchase agreement provided effectively against the risk of the parties not proceeding to completion. And we'll see this again in clause 2.4. This is where the contract makes provision for due diligence. The fourth payment will only be made upon completion of due diligence. We have the obligation on the parties to cooperate with the purchaser, and at the penultimate line of that paragraph, it reads that in case the company's sellers are unable to fulfil the requirements of the purchaser and/or the due diligence is unsatisfactory on account of non-cooperation or incorrect information or misrepresentation or concealment by the company's sellers, the company's sellers shall be bound to return the already received amount of 3 million dirham within 7 days of first written demand of the purchaser, and in case such demand is not met, they will be able to present the cheques for attaching the security checks. It should also be noted that that clause provides that the purchaser shall continue to remain as the owner of the vehicles and the trademarks in case the transfer formalities have been completed, and also that the purchaser shall only reassign the trademarks to the sellers upon receipt of all expenses incurred, future loss of profits, damages and compensation to be paid to the purchaser to be calculated from the 1st of January onwards. Again, we see reflected in the contract is the provision for the return to the purchaser of expenses or losses suffered. It's clear throughout, it's a running theme throughout this contract, that if it doesn't proceed to completion, the purchaser should not be out of pocket. And this is, provisions are made to this effect throughout it. And as we'll see, this is the basis upon which the claimant makes his claim for reimbursement of the 6.8 million odd that he incurred through paying suppliers, through advancing sums to the company, in part performance of the contract. The contract then didn't complete, and he now seeks repayment of those sums pursuant to the provisions of the contract. And in my submission, clearly the appropriate construction of the contract is that that was what was envisaged by the parties at the time. And we'll see that, and there's a particular clauses that we'll be relying on in a moment. At paragraph 2.5, we see the provision for the appointment of the claimant or his representative to manage the company until such time as the transfer of the shares takes place. And if, or indeed if they are not, until they are not affected. Paragraph 2.6 is a provision in relation to the profit and loss after the 1st of January 2016. Again, profit and loss prior to that date should be received by or borne by the sellers, and after that date should be received or borne by the purchaser. And this is one of the aspects that we rely upon as a basis for the expectation under the contract that the purchaser, the claimant, will be incurring expenses from that date. Then we have provision in relation to the bank accounts. It's relevant to the claim, but I don't need to go through it. That's paragraph 2.7 for these purposes. Then at paragraph 3, we have various representations and warranties provided by the defendants. I'll just alight on one on the following page, at page 177, and that's Roman numeral 5. And we'll see the information provided by the sellers to the purchaser is the correct information, and they've not concealed any material fact from the purchaser's knowledge of which would otherwise deter the purchaser from purchasing the shares or investing in the company. It's interesting that there's provision in relation to that at this juncture. But more relevant to today's purposes, we have on the following page, at page 178, the representation Roman numeral 13. And here, I'll just read it out for the benefit of the transcript. Sellers hereby confirm that there exists no claims, liabilities, litigation, contractual, or any business obligations of the company with any third parties except that is informed by the sellers to the purchaser in written at the date of signing this agreement. And sellers shall be fully liable of such obligations whatsoever, and sellers agree to fully indemnify, compensate the purchaser any claim, damages, litigation brought against the purchaser or company accruing on account of any act of the sellers, the company, on or before the 31st of December 2015. Obviously, a number of the, in terms of the purchaser's obligations, any obligations that arose prior to December 2015, for example, in relation to payment of suppliers, is very clearly the responsibility of the sellers. And to the extent that they don't meet those responsibilities, as we'll see from the re-amended particulars claim, they should obviously compensate the claimant in relation to any expenses incurred. It's clearly the provision is made in relation to that. And at clause 14, we see the confirmation that well, I won't go into detail of it. It's another provision in relation to the financial division between the parties, assuming that we proceed to completion. For present purpose, I'll just move on to Roman numeral 60. And this is the focus of one aspect of the claimant's claim today. And there we see provisions made that the sellers confirm that they will fully cooperate with the purchaser or his nominee in the running of the affairs of the company and its business till such time the transaction as stipulated in this agreement is fully complete to the satisfaction of the purchaser. However, if in the sole opinion of the purchaser the due diligence fails, then the purchaser as a right may not transfer the shares in his or his nominee's name. In such an eventuality, all expenses incurred by the purchaser from 1st of January 2016 in or for the company shall be returned by the sellers with immediate effect as guarantors back to the purchaser. This is in addition to the other consideration already passed on to the sellers under Clause 2 of this agreement. Now, from this clause, in my submission, it's overwhelmingly clear that there was an expectation that the parties envisaged that the claimant would incur expenses from the 1st of January 2016 when he was undertaking the management of the company. Furthermore, it makes explicit provision for the repayment of those expenses in the event that completion does not take place. Now, in terms of what those expenses comprise, we see the reference to in or for the company. In my submission, it's clearly the claimant clearly has a real prospect of success in contending that payments that he made to suppliers on behalf of the company, for the benefit of the company, would be included in this provision. Not only that, in referring to this reimbursement being in addition to the other consideration already passed under Clause 2, and we've seen that that's the purchase price, in my submission it's overwhelmingly clear that it would be expected that there would be other substantial expenses that should be reimbursed. It's for those reasons also, and this accords with as I said, the running theme throughout the contract. For example, the giving of security in relation to the purchase prices, to allow for the claimant not to be out of pocket if we don't proceed to completion. Just in passing, my learned friend in his skeleton arguments makes a reference to an apparent attempt by the claimant to cast this as some sort of guarantee. And how can it be the guarantee if the sellers are only guaranteeing their own liability? Well, just in passing, obviously the reference in this clause is to the sellers, i.e. the first and second defendants, not the company, which is being sold. And so if it is a guarantee, it could well be a guarantee in relation to the company's liability. But that's obviously not the primary basis upon which we are making this claim. The basis is on the primary obligation of the defendants to repay and reimburse the claimant for its expenses incurred. In the following clause, clause 17, Roman numeral 17, we see how this expectation is carried on throughout the contract, where we have a reference to the issuing of checks from their personal accounts to the purchaser as security against the purchases made by the company from the 1st of January 2016 onwards for routine business activities, and that those checks would be returned at the time of signing the amended MOA before the relevant authorities in the UAE. Again, there's an expectation that monies would be incurred by the claimant for routine business activities. This is the sum and extent of the claim, the disputed part of the claim anyway, being made by the claimant. In those it's simply, as I said before, it's astonishing that the defendants are objecting to this aspect of the claimant's claim. Just to continue through the contract, just to give you to introduce it, we see the purchaser's warranties at clause 4, the company's warranties at clause 5. Turning on to page 181, we see a reference, and this is you'll have seen a reference, Your Excellency, to second numbered clause 5. Unfortunately, the numbering in this contract goes awry, but at second number clause 5, at page 181, we see the reference to indemnification. And here, this is another clause that is being relied upon by the claimant. I'll just read it out for the benefit of the transcript. In the event that the sellers breach or is deemed to have breached any of the representations and warranties contained in this agreement, or fails to perform or comply with any of the covenants and obligations set forth in this agreement, sellers shall refund into ILYA, subject to other terms of this agreement, all payments made by the purchaser under clause 2 of this agreement. That's a reference to the purchase price. And compensate and hold harmless, indemnify and defend the purchaser or his nominee and each of his directors, officers, shareholders, owners, etc., from and against any losses suffered, damages incurred, or all payments made by the purchaser under this agreement, to the extent such damages arise or result from a breach, omission, or incapability of the sellers of any such representations or warranties and omissions or violations of any terms or covenant of this agreement, and or failed due diligence. In my submission, this clause is extremely wide and is another reflection of the attempt through the contract to ensure that the claimant is not out of pocket in the event that completion does not take place. Now, there may be arguments at trial as to what in fact is included in this, but in my submission, as I will attempt to make good throughout today, the claim being made by the claimant there's clearly a real prospect that all of the claims being articulated by the claimant will fall within the definitions comprised in this clause. And it would be unfair and wrong, in my submission, for the claimant to be shut out at this interlocutory stage without the benefit of proper evidence and disclosure and all the procedural steps that proceed to trial. Just highlighting further, clause 8 at the bottom, we see the dispute resolution clause, and we see there how widely that is drafted in giving jurisdiction to the DIFC courts, and the reference to any differences or disputes which arise in relation to this agreement in any manner. Now that rider is important and should be borne in mind when we consider the provision on the following page, where it provides that failing the mediation, such disputes, i.e. any differences or disputes arising in relation to this agreement in any manner, shall be finally submitted to the exclusive jurisdiction of the DIFC courts UAE. Now, my learned friend tries to make a distinction between this and various formulations that she puts forward in her skeleton argument. But in my submission, this is equally as wide, if not wider, than the various formulations that she identifies, and is clearly not a basis for shutting out the claimant at this early stage. And finally, just on the contract, we have the governing law provision at clause 10 in relation to DIFC law. Now, having introduced the contract, I just want to pick up the narrative very briefly so we know what in fact took place. Now, while the defendants did initially perform their obligations under the SBA, including through appointing the claimant as manager of the company on the 14th of January 2016, in late 2016 and early 2017, a dispute arose in connection with the due diligence, the detail of which is not important today, but essentially the claimant contended that the balance to be paid out pursuant to the mechanism for calculating the purchase price was only 91,000 dirham, whereas the defendants maintained that 8 million odd was still due. In those circumstances, the defendants resisted the claimant's attempts to complete. At that stage, the claimant still wanted to complete and secure the transfer of the shares, but was prevented from doing so, and the defendants took back control of the company and forcibly ejected the claimant from the company's premises and prevented him from managing the company. It's in that context that the claimant brought its claim in August 2017, and indeed its ex parte without notice application for an urgent injunction in order to secure completion of the SPA. That claim was particularised as per the original particulars of claim of that date, and my learned friend seems to suggest, or attempts to suggest, that the re-amended particulars of claim is a speculative attempt to broaden the claimant's claim. In fact, it is no such thing. The ingredients for the claim are all contained within the original particulars of claim. Unfortunately, those particulars of claim, as we'll come to see from Deputy Chief Justice Steele's judgment, was not as clear as it might be. It was drafted in haste ahead of an urgent application, but nevertheless, it contained all the elements that we're seeking today. In particular, it was seeking specific performance of the share sale and purchase agreement, and in particular the transfer to the claimant of the shares and assets of the company, and we can find that for the Excellency's reference at paragraphs 59 to 60 of the original particulars of claim, and that's at pages 421 to 422 of the bundle.
Four hundred there.
421 to 422. And then, I can tell you how that draft. I mean, it's simply showing that the claim for specific performance there, first the transfer of assets, which is maintained to a degree, and then in paragraph 60, specific performance of the transfer of the shares. And then, by those particulars of claim, the claimant was also seeking repayment of sums paid to the defendants pursuant to the share sale and purchase agreement. In particular, monies not included in the purchase price. Again, that is a heralding of the claim as it's being articulated today. Now, that can be found at paragraph 61, simply below. It's worth looking at this paragraph. It's unfortunately not drafted as clearly as it might have been, but nevertheless it has the elements of the claim that are being made today. And if we just read it, try and arrive at its meaning, it reads, further or alternatively, the claimant seeks 1. The return of the monies taken by the first and second defendants under the DRC law, the Litigation DRC law number 5, on the basis that monies taken by the defendants were investment monies held by the company on trust for the claimant, in relation to which the defendants owed the claimant fiduciary duties and or a duty of care, which had been breached. So that's the first one, that's in relation to monies that were taken out of the company. Relevant today, secondly, we have and or damages for breach of contract, and then and or payment under clauses 1.1 and 2.1 of the SPA, it's in relation to the purchase price again, on the basis that matters set out in paragraph 30 to 55 above, to the extent that these are not included in the purchase price. So we have there the reference to paragraphs 30 to 55 above, and then a qualification saying to the extent that these are not included in the purchase price. If we move back to paragraph 36 in the original particulars of claim, it's at page 417, which is obviously one of the paragraphs being referred to there. At paragraph 36, is there an Excellency there?
Yes, we can.
Yeah. We see the reference there in the final sentence to between the 11th of January 2016 and June 2017, the claimant injected working capital into RAG of approximately 6.8 million dirham. And then further, at the request of the defendant, the claimant paid 750,000 on the 30th of June 2016 and AED 500,000 on the 30th of July 2016 towards payment for the purchase price. Besides such payments not yet fully included. So the point there is while the claim is no doubt concertinaed and summarised in Clause 61 perhaps to too great a degree, nevertheless, we already have a setting up of the claim for the very same 6.8 million that is being claimed in the reformulated particulars of claim today. So, in that context, to try and say that this is coming as some sort of surprise or that it's some sort of abusive process, in my submission, is without foundation. So, on the just to follow the chronology, in response to this original particulars of claim, at the following page 448. We see the defence and counterclaim filed on the 21st of September 2017. I'm not proposing to take Your Excellency through this in any detail, except to point out, first, that it extends to some almost 30 pages to page 475. It's not a concise document. And to some 163 paragraphs indeed. But not only that, if we look at the counterclaim, we see references, and perhaps the best place to look at this is in the relief sought, pages 473 to 474. We see references to relief sought that don't appear to be referred to anywhere else in the pleading. For example, purported claims for damages for unlawful interference, that's a Roman numeral 7, for damages for unfair competition at Roman numeral 10, or damages for harassment and damages for malicious prosecution, and various others that don't seem to have any proper basis. As to the substance of the claim, and from what you can actually discern from the pleading itself, essentially the defendant denied the claimant's entitlement to specific performance, contended that the claimant's remedy for breaches of the SBA were limited to compensation, and referring indeed to, as well, perhaps worth picking that up, to Clause 5 of the SBA, i.e. the indemnity provision we looked at, and that's at paragraph 41 of the defence and counterclaim, at page 455. It follows that the claimant's remedy, if any, for the breaches by the defendants of their obligations under the agreement which is denied, limited to compensation as confirmed by the express terms of Clause 5 of the SBA. Just mention that in passing. In terms of the pleadings, the reply in defence to counterclaim was filed on the 1st of October 2017, and that can be found at pages 476 to 487, and the reply to defence to counterclaim on the 15th of October 2017, and that can be found at pages 488 to 492. All these references are included in my skeleton argument, if that assists.
Yeah.
Now, picking up the procedural background, as mentioned, in August 2017...
But the parties still, they don't reach case management conference yet, right?
No, they haven't.
Since 2017. Just fighting on to amend the claim.
That is the only substantive.
But Ms. Bishra, you don't file a contest of jurisdiction or nothing?
Well, I'm going to address Your Excellency on that very particular issue, because that's really the substance of our response and our objection to these proposed amendments. But I'll allow my learned friend to finish before I address you on that.
Yes, continue.
So, as mentioned, the claimant made this urgent application for an injunction, a mandatory injunction, requiring defendants to complete, and did that in August 2017. Now, while Deputy Chief Justice Steele didn't accept the claimant's case in relation to that, and didn't make the mandatory injunction, what he did do was to accept that the claimant's case was at least arguable, sufficient to merit the continuation, in effect, of an injunction made by Sir Richard Field on the 21st of August 2017, prohibiting the defendants from causing any liability on the company's business. And we can see that in the earlier bundle, the January 2018 bundle, at tab 6, page 62 to 65. So this is the order of Justice Sir Richard Field. And we see at page 63, number paragraph 3, that's the injunctions made, saying until the return date or further order of the court, the defendant is prohibited from causing the third defendant to incur any liability or to deal with or dispose of any of its assets save in the ordinary and proper course of business. Just turning the page, it's worth mentioning that these are the claimant's undertakings. Paragraph 7, where the claimant had to provide an undertaking that any proceedings commenced in the onshore Dubai court dealing with matters arising out of the SPA would be discontinued forthwith. That was right at the outset of these proceedings. We then go on to the order of Deputy Chief Justice Steele of the 10th of October, and that's at page 69 of the same bundle. And we see there at page 70, again paragraph 3, Deputy Chief Justice Steele maintaining the injunction, maintaining the effect of the injunction of Justice Sir Richard Field. And then at page 75, at paragraph 24, accepting the claimant's case as perhaps at least arguable. And then at paragraph 26, on the following page, at page 76, explaining why he is maintaining the injunction in relation to the company. Now, in those contexts, quite properly, I think, in my submission, the defendants aren't contending that the entire claim doesn't have real prospects of success. In my submission, it's not open to them to do that. And so the focus today is in relation to the 6.8 million, the further particularisation of the 6.8 million. And that indeed was the focus, as Your Excellency has already alighted on the previous amendment application, the December 2017 amendment application. Now, it's noted that, I think, just to correct the position, there may have been at least a limited case management conference, I'm looking at my learned friend here, in December 2017, at which it was directed that we should make an application to amend it.
Your Excellency, I'm being told that there was a limited CMC at that point. I wasn't in attendance on that occasion, being on maternity leave, but yes, I'm being told that it was very limited and dealing with pleadings only. There were no directions given at that point for the administration and progression of the case.
Thank you.
No. Just to clarify. So, in response to that, the claimant prepared its application to amend at that stage, and we can see the amended particulars of claim, the proposed amended particulars of claim that the claimant sought to rely upon. And that's, again, in the earlier application bundle, the January 2018 application bundle, and we can see those at page 297 to 322.
And which tab, please?
Sorry?
Which tab?
39. I think so, yeah. So these were those proposed by the claimant at that stage. Now, I'm going to focus on those relevant paragraphs today. The majority, or a large proportion of the amendments sought were allowed, and we'll see those reflected later on. The focus again today is on the 6.8 million. So I'm just going to focus on how that was dealt with in the amended particular claim here. So perhaps unfortunately, in circumstances where we are today, in an attempt to limit the costs of the amendment application, the claimant decided to work off the original particulars of claim, because we've already seen was not perhaps as felicitously drafted as it may have been. And that decision may have been counterproductive. But in this amended particulars of claim, what the claimant sought to do was to introduce an alternative claim seeking the return of monies and/or damages and compensation pursuant to clause 2.4 and clause 5 as an alternative to his claim for specific performance. And we can see this at paragraph 60A at page 145. Paragraph 60 there. That's the wrong reference. At 316. And we'll see there, in the alternative to the case pleaded at paragraphs 57A and 59 to 60 above, that's the specific performance case. In taking steps to cash the checks, the claimant by his conduct accepted the defendant's assistance with the fundamental performance of the FPA and seeks a return of the monies he's paid towards the purchase price and/or damages and compensation pursuant to clause 2.4 of the SPA and/or indemnity pursuant to second number clause 5 of the SPA. So that's one of the aspects that were, and that's an amendment that was permitted in that application. More relevant today, the claimant also sought to particularise and quantify his claim for the 6.8 million. We'll see this at paragraph 60C.4 and following. That's on the following page. And we see at 60C, this is brought pursuant to the indemnity at clause 5, at least at the top there, and then relevant to the 6.8 million at 60C.4, we see the reference to the various payments, so the same payments were being relied upon today, what substance they are, and that is how it was put at that stage. And we see also in paragraph, for example, that carries on, I'm not going to go into the detail of it, in circumstances where the amendments weren't allowed. But then at 60E, we see the alternative claim in relation to restitution and damages. It's also to be noted that through this draft, paragraph 61, which is the provision that I took your lordship to, and this can be found in paragraph 319, which included the claim for monies not included in the purchase price, was deleted. So it was a reformulation of that claim in order to further particularise it. Now, as your lordship will have seen, Deputy Chief Justice Steele, in his judgment, didn't accede to the claimant's application on that day. And if we can pick up that judgment, I just want to take directions through. It's at tab 1, page 1, or page 1 in front of it. The schedule of reasons starts at page 2. Now, has Your Excellency had an opportunity to read this previously? Yeah. I'm just going to highlight a couple of points. We'll see at paragraph 1 the reference to the pleadings in this case, the pleadings we know, but in particular the statement of claim, being prolix, confusing and repetitive. At paragraph 2, we see the focus on the clauses the paragraphs that I took you to today concerning 6.8 million, i.e. paragraph 60C, 60D, 60E, and 61. The recital at paragraph 3 of the indemnity at clause 5, which I've already taken Your Excellency through to, and at paragraph 5 we see the reference to former paragraph 36 of the particulars and the reference to the 6.8 million that we were talking about. Deputy Chief Justice then goes on to describe the proposed amendments. But a key for today's purposes, at paragraph 7, he records how this is a rough summary of the claim for an indemnity. It refers to the fact that there's some concern that the assertion of the claimant's witness statement, there is no documentary evidence of the making of any loans by Farmex, let alone in the terms on which they were made or payments received, nor is there any witness statement from the claimant's brother. Obviously, in the application today, these criticisms have been addressed. And importantly, the Deputy Chief Justice goes on to say that in any event, it does not appear to be alleged that the loans or any repayments were made under the terms of the SPA. Now, that was the view that was taken by Deputy Chief Justice Steele on that occasion. Now, whatever the merits of that view, and obviously don't seek to go behind that decision, as we'll see, this is not the case today. The claim has been properly pleaded, and it's explained how, by reference to the SPA that I took you through, and on the basis of provisions that I took you to, how the payments made were made under the SPA, and therefore fall within the terms of the indemnity clause 5. It should also be noted that that's not the only way in which the claim is put. The claim is also put pursuant to clause 316, and on the basis of seeking an equivalent sum in damages on the basis of breach of contract. But in any event, to the extent that this claim was criticised, this aspect of the claim was criticised by the Deputy Chief Justice, those matters have now been addressed. At paragraph 8, the Deputy Chief Justice goes on to explain that how on that basis noted another way, records the defendant's submissions in relation to the prospects of success of the claim, and then, perhaps moving on to in the interest of time, continues to describe the various amendments made before coming to his conclusion at paragraph 12 on the following page, page 4. And this, I will read this for the benefit of the transcript, states that it is now appropriate to focus on clause 5. As an indemnity provision, it is in relatively standard form in 2 parts. The first part requires the seller to refund payments made by the purchaser by way of the purchase price under clause 2 when in breach of the agreement. The second part requires the seller to identify the purchaser and his officers in respect of losses sustained by reason of the seller's breach, together with payments made by the purchaser under the agreement. Whilst the clause may be broader than furnishing protection against third-party liability, it would not appear to be concerned with payments made outside the scope of the agreement. The rationale for the decision in my submission was the fact that at that stage it was the Deputy Chief Justice concluded that it hadn't been pleaded that payments were made under the agreement. Now, in my submission, it's always been the claimant's case that they were made under the agreement, but nevertheless, as a matter of pleading at that stage, he reached that conclusion, and on that basis, reached the decision that they therefore didn't fall within clause 5, and also didn't fall within, and we'll see this in paragraph 13, the jurisdiction of the DIFC courts, and that's the final 4 lines of that paragraph, saying that if that analysis was correct, there would not be claims which can be pursued under the indemnity. Indeed, they would not, on the face of it, be claims falling within the jurisdiction of this court. It is only in respect of claims arising from the SPA that the parties have adopted into the jurisdiction of the DIFC courts. So that's the basis for the judgment. However, recognising that this would obviously cause great potential prejudice for the claimant, Deputy Chief Justice went on to say in paragraph 14, that all said, the difficulty facing the claimant, and indeed the defendants, is that the pleading as a whole is fairly incoherent. It is tempting to require the whole document to be reviewed and reformulated. Certainly, the claimant should review the pleading in the light of the difficulties and inconsistencies outlined above. But as regards the application to amend, I will confine myself to an order that application be refused as regards the revisions to paragraph 60 and 61 of the pleaded case. This is without prejudice to a further application. Now, in my submission, the Deputy Chief Justice couldn't be any clearer that his decision was without prejudice to a reformulation of the way in which the claim was put.
Sure.
In fact,
he keep the door open for you to apply again.
Precisely. And particularly in relation to this aspect of the claim, by refusing these provisions, he said this is without prejudice to a further application. So there's simply no question of res judicata, or this has already been decided. While there has been this decision, the Deputy Chief Justice said, well, if you can reformulate it in a way that addresses these concerns, is properly pleaded, then while you're at it, why don't you have a go at reformulating the whole claim? Because in the long run, it'll save the parties costs. Go ahead and do it. And that's the invitation that the claimant has taken in this application, and quite properly in my submission.
So no appeal from this judgment. I mean, you don't appeal it.
No, there's no application to appeal it, but there was no need to appeal it in my submission, because the judge made specific reference to a further application, and you can have another go at pleading it. And indeed, that is what those representing the defendants understood from this. At page 496 to 497, we find their letter of the 25th of February 2018. Page 496.
496.
Yeah. And this is in the context of seeking clarification of the judge's order by the claimant, and characteristically, the defendant's representatives opposed the request for clarification, which is somewhat surprising. But relevant to today, paragraph 3, we see the understanding, or the defendant's understanding, of what was meant by the judge's order. And they state there, it is therefore with that background that the Deputy Chief Justice refused the application as regards to the revisions to paragraph 1661. It is obvious that despite its reservations, the court is allowing the claimant a further opportunity to make a renewed application that addresses the confusion and inconsistencies in the claimant's pleading, and particularly paragraphs 60 and 61. This gives the claimant a further opportunity, if it can, to plead a coherent and evidentially supported case in respect to the farmer's claimants that fall within the SBA in the jurisdiction of the DIFC court, which so far it has failed to do. And then at paragraph 5, more specifically, it is for the claimant to clarify its case. And if in such an effort the claimant wants to stand by any wording of paragraph 1661, he is free to do so. If the claimant wants to change the wording, he is equally free to do so, not just in respect of those paragraphs, but also in respect of any other paragraphs in his pleading. It couldn't be clearer what was meant by the judge, and indeed what the defendants anticipated. In those circumstances, to now try prejudice in my submission is a submission that's not open to me. And I have the references to these, but I am conscious of the time. I have the references to the registry's understanding going forward in my skeleton argument, and for your Excellency's reference, these are firstly at page 498 to 501. And there, in confirming the claimant's understanding of the order, they then stated, it does not follow that in the interests of clarity and consistency, further amendments to the paragraphs, whether amended or not, are not required. In fact, it may be worse. It's the following page, 498. It's an email from the registry. That's the second sentence. Now, on the 1st of March 2018, the claimant did file a revised amended particulars of claim in line with the clarification, but reserving its right to make a further application. This is at page 502. So that essentially, that amended particulars of claim is in the bundle. Simply included those amendments that had been allowed, but obviously didn't make the amendments that had been refused, and then reserved the right in line with the defendant's understanding and the registry's guidance to make a further application. and again in its letter of on the following page, at pages 503 to 510, the claimant went on to explain that it did intend to make a further application or to re-amend amend a particular claim, to particularise its claim for the recovery of 6.8 million, and stating that in the absence of being provided with further time, would make a further application. And we see this at page 505, and there's the substantive paragraph 2. I'm not going to go through the detail of the letter, but the claimant's intention to file a further amendment application, and this is in relation to the 6.8 million. We see in paragraph 2.4 the relation reference to 6.8 million there. So this is the context in which the present application is made. It's not simply another attempt to reheat the old application. It was a process that was obviously envisaged by the court and the parties. To contend now somehow that the application is an abusive process, in my submission, is simply without foundation. Having addressed you on the background, I just want to make a handful of submissions in relation to the relevant law. Now, these are dealt with at paragraphs 29 to 36 of my skeleton argument, and it may be helpful to have those paragraphs to hand. Now, I don't think, in relation to the law applicable to an application to amend pursuant to Rule 18.22, there is much between us on the relevant TIC law that should be applied. You see at paragraph 29, I set out the relevant provision of Rule 18.2. At paragraph 30, I mentioned in passing Rule 18.12, which provides that applications to amend where permission of course is required, and that's the title to the provision, and then it says at 18.12, questions of amendment and consequential amendment should wherever possible be dealt with by consent. A party should consent to a proposed amendment unless it has substantial grounds for objecting to it. Now, while there's no guidance in the rules as to the approach that should be taken by the court, it has been dealt with in the authorities, and from that we can conclude the test for whether the court should grant permission under the rule requires simply that the amendment be properly pleaded and has a real prospect of success. We can take that from the case of Orion Holdings and Mohammed Abu al-Hajj, which is at tab 3 of the defendant's authorities. And I will just, particularly on paragraph 22, well, we can pick up the judgment at paragraph 16.
Which tab? 3?
Tab 3, yes.
Well,
Tab 3, yes. It's tab 3.
Abu al-Hajj case is tab 2.
Yes, it's tab 2 in mine too.
Orion Holding and Abu al-Hajj is tab 2.
Okay, well,
It's okay. Anyway.
I'm in the defendants, but anyway, it doesn't matter which one. That's fine.
Actually,
let's work with the claimant's one.
It's yours.
Yeah, I was referring to the claimant,
okay.
to the defendant. Sorry, just to be confusing. So which one are we working on?
Claimant.
Okay. If we turn first to paragraph 16, that's where the judge introduces the amendment application. I'm not going to go into the detail of this particular claim, but at paragraph 22, having set out the parties' submissions, the judge states very shortly that, and this is His Excellency Justice Shannon al-Salaweh, Sawalhi.
Sawalhi.
Sawalhi. I apologise. Paragraph 22. The test for whether the court ought to grant permission to amend under RDC 18.22 requires that the amendment be properly pleaded and have a real prospect of success. At paragraph 25, we can see some of the relevant factors that can be taken into account, and these include the stage at which the application is brought in the proceedings, and accordingly, whether the respondents suffer any prejudice as a result of the application. At paragraph 33 of my skeleton argument, I refer to the case of Leedham and Oxford Investment Managers, the decision of Justice David Williams. We don't need to take this up, I don't think, but it's simply the court noting in that case how the provisions in the DIFC rules follow closely the English CPR rules, and as such makes reference to the leading English case of Cobbold and Greenwich, containing a just dictum of Lord Justice Peter Gibson. And I set out the well-known dictum of Lord Justice Gibson at paragraph 34. And again, I don't think we need to take up the authority itself. But as it states there, the overriding objective is that the court should deal with cases justly. That includes, so far as practicable, ensuring that each case is dealt with not only expeditiously but also fairly. Amendments in general ought to be allowed so that the real dispute between the parties can be adjudicated upon, provided that any prejudice to the other party or parties caused by the amendment can be compensated for in costs, and the public interest in the efficient administration of justice is not significantly harmed. And finally, there is always prejudice when a party is not allowed to put forward his real case, provided that that is properly arguable. And I extrapolate to paragraph 35 the principle that I say the court should apply in considering an amendment application, namely, it should be properly pleaded, have a real prospect of success. Any prejudice can be compensated in costs, and the public interest in the efficient administration of justice is not significantly harmed. Paragraph 36, I don't think this is controversial. When considering whether the claim has a real prospect of success, as is set out in the case of Papadopoulos, which is in the authorities bundle, the court must consider whether the claimant has a realistic, as opposed to fanciful, prospects of success. And a fanciful claim is one that is entirely without substance. In my submission, we're just clearly not in that arena today. And the court, while not required to take everything the party says in witness evidence at face value without analysis, the court should avoid conducting a mini-trial without disclosure or oral evidence. Now, having set out the law that the court should be applying, if Your Excellency would like me to take you to that authority, I'd be very happy to do so.
I'm fine. It's okay.
Having set out the law, I'd just like to go through the draft re-amended particulars of claim so that we know what we're dealing with. Now that's at, I've put the tab number, so it's tab 6, but I'll give you the page number.
18.
So, 14.
18.
13.
29.
Okay. Put
Page 13 of the bundle.
Yeah.
So, if we could just go through this, just so we see where the claims ended up.
The paragraph which you want to amend. This is the.
Well, so this is the clean version of the particulars of claim. Now, we can see, and I'll just take you to it, and the best place to do so is probably at page 329. is annexed to the defendant's evidence. This is the marked up version of the draft re-amended particular claim. And just flicking through it, and you'll see this is a colour code used by the, I don't know whether Your Excellency has a colour version, I don't, but,
Yeah, I have.
but I think the red markings are those the darker, which I think are red, those markings are those aspects that are objected to by the defendants. The yellow ones are those that are objected as a matter of formality rather than substance. But the reason I'm taking Your Excellency to this is that you will see from the pleading that the claimant has taken Deputy Chief Justice Steele's advice to heart and has reformulated the entire plea. Now, there are aspects that remain the same. There's some drafting that finds its way into the new pleading, but you'll see that there are a substantial number of changes being sought to be made. So I'm not proposing to take you through every single individual amendment. It's accepted that what the claimant is seeking to do is to reformulate the claim. Now, the controversial aspects of that have been objected to as a matter of substance by the defendants relate to the 6.8 million being claimed, in relation to which repayment is being claimed. And that's what I'm going to focus on when we go through the amended pleading. But I don't think it's necessarily helpful to go through the marked up version because it's quite a confusing document, if that's okay. So if we could go back to page 13 of the Bible and look at the original, well, not the original, but the clean, re-amended particulars of claim that the court is inviting permission, sorry, the claimant is inviting permission to be granted to file. And we'll see at page 13, section A, the claimant sets out the parties in some detail, including the relationship with the claimant's brother, Sajid SABOOWALA, paragraph 2, and pleading and stating that Sajid SABOOWALA has been in possession of a general power of attorney in the UAE from the claimant since the 27th of February 2012. Then goes through the other parties that hasn't changed a lot, including paragraph 6 to 8, a summary of the way in which the claim is now put, to give a roadmap of where the claim is going. We'll see, we've been there today, paragraph 6 is reference to the SPA, which is, and paragraph 7, reference to the defendant's fundamental repudiatory breaches of the SPA set out in detail at paragraph 83. Claimant accepted, thereby lawfully terminating the SPA. The claimant claims repayment of all sums paid to the defendants and all expenses incurred pursuant to the SPA, as he is entitled to do under the explicit terms of the SPA, together with damages and other relief. And then the claimant maintains the claim's specific performance, but only insofar as in relation to the transfer of assets, rather than the shares themselves. At section C, the claimant sets out the relevant background to the claim. I just go on to refer specifically to paragraph 14, where the relationship with Mr. Sajid SABOOWALA and the way in which Mr. Sajid SABOOWALA effected payments for on behalf of the claimant to the company is described. If I could invite Your Excellency just to read that paragraph, paragraph 14.
It's okay.
And then at paragraph 17, we have the 17 and 18 have the introduction of the share sale and purchase agreement. We've already been there. I would, at paragraph 18, the final line, I would just draw Your Excellency's attention to the reference that the claimant will rely at trial on the SPA for its full terms, meanings and effect. I go on, the claim goes on to refer to the relevant, particularly material terms of the SPA in the rest of this section. But my learned friend seems to make some sort of point that the clause 8, you remember that was the dispute resolution and the jurisdiction clause, is not actually quoted in this in these particulars. Well, I mean, it's incorporated by reference. The claim obviously relies upon that for the founding of jurisdiction in relation to the claim. The fact that it's not, in the interest of brevity, not quoted in full in this pleading, in my submission, simply goes nowhere. In the pleading, as I say, the claim sets out the provisions of the SPA, and that goes on all the way through to page 18, and then at the beginning of page 19 is still the provision of the SPA, but it deals with the specifically with provisions relating to due diligence, which I've already taken, Your Excellency, to. You'll see at paragraph 29.2.3 the reference to the reassignment of trademarks to the first and second offence only upon receipt of all expenses incurred, future loss of profits, damages and compensation to be paid to the claimant to be calculated on the 1st of January 2016, such payments to be made within 1 month of the claimants to market. Again, I'm just pointing that out to demonstrate the claimant's reliance on that provision in relation to his entitlement to the return of expenses and future loss of profits. At section E, there's a reference to management of the company and responsibility for entitlement to profits, and that recites at clause 2.5 and 2.6. At paragraph 34, we see the reference to, and this forms the basis of part of the claimant's claim. It's pleaded that pursuant to clause 2.6 and or in any event in circumstances where the claimant was entitled to and did manage and or supervise or have responsibility for the management of the company, pursuant to 2.5 or otherwise, just as the claimant was entitled to any profits generated by the company from the 1st of January 2016, in circumstances where any losses incurred by the company from that date were also to be borne by him pending completion or the failure of the due diligence process. From that date, the financial needs of the company, including cash injections, were equally to be met by the claimant under the SPA. Consistent with this effect of clause 2.6, as referred to at paragraph 37.4 below, clause 316, which I've already taken to court 2, provides that if in the sole opinion of the claimant the due diligence fails, all expenses incurred by the claimant from the 1st of January 2016 shall be returned by the first and second defendants for immediate effect as guarantors back to the claimant, in addition to the consideration already paid to the first and second defendant pursuant to clause 2 of the SPA. I'm referring to this simply to make good the fact that the claimant's reliance on this provision effectively to demonstrate that the claimant, the contract was making provision that the claimant would not be out of pocket. And this is the basis of the claim. To say it was envisaged that expenses would be paid by the claimant, but in the event that completion didn't take place, they'd be repaid. That is as simple as it gets in relation to the claim. And at paragraph 35, that's where I draw these conclusions from it. That it was envisaged the claimant would incur expenses in or for RAG, and such expenses would not be limited to losses incurred, but also sums advanced. And then we recite the representations and warranties, including particularly 37.4, clause 3.16, which I've taken, Your Excellency, to. And at paragraph 38, having made a reference to purchases for routine business activities, again, which I referred to, we see, in addition, the implication of the term in relation to the expectation that the claimant would make payments on the claimant's behalf, on the company's behalf. At paragraph 40, we set out the indemnity, already described, before moving on to performance and breach of the SPA at paragraphs 43 and following. I've described how initially the contract was performed, and these include through the injections of cash by the claimant, and that's paragraphs 48 and following, and expenses being incurred by them. And here, at paragraph 49, we see the statement from the 1st of March 2016, the first and second defendants stopped making payments for RAG's routine business activities. And paragraph 50, accordingly, pursuant to the obligations and responsibilities I've already taken the court to, the claimant injected working capital into the company for the specific purpose of paying the company's creditors, funding the company's routine business activities, and easing its cash flow problems in the total sum of approximately 6.85 million dirham, as described in further detail below. And then it details in some particularity the specific payments that are made throughout 2016 by the claimant, albeit that payments at paragraph 51 were effected by Farmex on the claimant's behalf, pursuant to the arrangement we've already looked at. We see in relation to each of them how the payment was for the purpose of paying suppliers and for routine business activities. At paragraph 52, we see specific payments in relation to the payment for essential machinery and cars. And then at paragraph 54, we have further payments, and these ones are in fact made by the claimant himself. And these represent almost a half of the sums being claimed. So to the extent that the defendants are trying to maintain somehow that the Farmex payments weren't made on the claimant's behalf, obviously that only is in respect of approximately half of the total sums claimed. Half of them were made by the claimant himself in any event. And it's perhaps unfortunate that the focus was so much on payments being made by Farmex at the previous period. Just turning the page again, just so that we continue through the pleading. We continue the narrative from pages 27 to 28, and then we introduce the performance in relation to due diligence, and this is where we have the breakdown in the performance of the SPA. And at page 30, we see the claimant demanding completion, and that obviously not being complied with. And finally, having set out all the narratives, at page 32, the claimant sets out in detail the breaches of the SPA that are relied upon. These are done according to the different stages at which these breaches were made. At 83.1, we have the breaches that are being relied upon the execution of the SPA, and these are in relation to failure to transfer various assets and breaching of duty to cooperate under various provisions, failing to make various disclosures. And then we have at paragraph 83.2, on page 34, we have various breaches in connection with the due diligence process. And then at 83.3, we have the failure to transfer the shares and to complete in breach of his obligations under the SPA. And then we set out various breaches in relation to satisfying debts and liabilities incurred prior to January 2016, which was at 83.4, which is in the region of some 9.45 million. And then allegedly at paragraph 83.5, transferring monies away from the company. 83.6, we set out the particulars in relation to the failure to cooperate, including 83.6.7, the failure to engage in the mediation process, which was obliged to under the dispute resolution clause at clause 8. My own friend somehow seeks to suggest that we're seeking to claim the costs of the mediation process as costs themselves. What we're claiming in relation to that is damages, and in terms of the losses that are caused by the breach of the clause 8. And it so happens that wasted costs in relation to that process would represent losses. So they're probably being claimed, those costs are being claimed as losses, not as costs. I just make that distinction because my own friend seems to suggest that we're not entitled to make that claim. I don't see the basis for that.
Your Excellency, sorry to interrupt, I just have one eye on the time. I'm quite conscious that we both have equal time to make our submissions, and therefore we're approaching an hour and a half now.
Yeah. Don't worry, I will give you your time.
I beg your pardon?
I will give you the time.
I'm grateful, thank you.
But sorry, my voice is not that. I have cold, sorry.
Your Excellency, just in terms of timing, I think it's helpful to go through the pleading in some detail. Once I've been through the pleading, it shouldn't take me too long to wrap up. At page 36, we have the claimant's acceptance of the defendant's repudiation of the SPA, and this is elaborating upon what was set out in the previous pleading and the attempt to cash the security checks as a result. And at paragraph 88, we have the pleading in relation to the claimant's acceptance of the non-performance of repudiation and the statement as to termination of the contract. And the subparagraphs there, the claimant sets out what he's claiming as a result of the termination of the contract. In particular, I draw your Lordship's attention to paragraph 88.2, where it's stated that pursuant to clause 316 of the SPA, in particular on account of the failure of the due diligence from the first defendants and second defendants' primary obligors and or guarantors, the return of all expenses incurred by the claimant from the 1st of January 2016 in or for RAG, including all those monies injected into RAG by the claimant or on his behalf, pursuant to his obligations under clause 2.6, in the sum of at least 6.85 million dirham, for the specific purpose of paying the company's debts to its creditors and or easing its cash flow difficulties, as set out in the paragraphs I've already taken to you, and or damages and compensation. And then at paragraph 88.3, the claimant then makes the same claim in relation to the same provisions. The same amounts, but pursuant to the indemnity. So, in relation to the 6.85 million, it's brought on two bases here. Firstly, under clause 316, and secondly, pursuant to the indemnity. And that's made good, we can see at paragraph 88.3, where reference is made to 6.85 million being claimed under the indemnity. So that's the claim and the entitlement pursuant to the provisions of the agreement. As it happens, the defendant hasn't complied with those entitlements, and so is in breach of its failure to do so. And that is pleaded at paragraph 89. So in not actually returning the expenses, including these amounts, it's submitted the defendant has in fact breached the agreement in not doing so, and that is pleaded at paragraph 89. Paragraph 90 is the alternative basis under quis post resulting trust is pleaded. Now, I will address this if necessary in reply. Just as a marker, in my submission, it is properly pleaded, in not least in identifying the specific purpose for which these payments were made. And I made that submission good in taking you through each of the payments and how, in summary, each of the payments and how they were, the purpose for which they were made. And as such, there is sufficient basis in the pleading for an objective analysis as to whether the payments were made and intended to be made subject to in effect, a purpose trust in relation to payment of suppliers or routine business activities. But if my learned friend continues to make that submission, I'll take you to the authority and explain how it is properly pleaded. And then the further alternative at paragraph 91 in unjust enrichment. Now, it's quite wrong to say that this aspect of the claim rises or falls on the basis of the quid pro quo resulting trust. It's a further independent claim for the sums claimed. At paragraph 93, this is where the losses suffered as a result of the breaches are set out, and they include, in paragraph 93.3, the sum of 6.85 million due to him under the two paragraphs. So this is where the damages claim for that amount is made, essentially. And then I'm not going to take you through, but you'll see at paragraph 97 and following the relief sought, and this simply summarises what is being sought. Now, the object of taking you through that rather laboriously is just to demonstrate that this is a properly pleaded claim. It goes through each of the ingredients for each of the causes of action pleaded in some detail, and it follows a logical format. In relation to the 6.85 million claim, as I've tried to emphasise, it's first brought pursuant to the obligation to repay expenses incurred under clause 360. It's secondly brought pursuant to the obligation to compensate and indemnify the claimant in respect of any losses suffered, damages incurred, or all payments made by the purchaser under the agreement, under the indemnity clause 5. And then, finally, the equivalent sum by way of damages on the basis that that sum represents part of the loss suffered by the claimant through the failure to proceed with due diligence and ultimately to completion. But in summary, as I said at the start, this is simply an aspect of the what was envisaged by the contract to make sure that the claimant doesn't end up being out of pocket in the event that the share sale and purchase agreement doesn't proceed to completion. And this is just one aspect of it in ensuring that that effect is taken up. In my submission, therefore, in light of the way it's put, it's submitted that there's simply no basis for contending that the amended claim does not have, at the very least, real prospects of success. In other words, it's not fanciful. That's not a high threshold to meet, and it's easily met by the proposed draft re-amended claim. And furthermore, it is properly pleaded. It's not only fully particularised, but it's supported by the detailed witness statements from the claimant and also from Sajid SABOOWALA, the claimant's brother, and corroborating contemporaneous documents. Now, I don't have the time to take you to your lordship to that at the moment, but just for your lordship's reference, at page 49 of the bundle, paragraph 15, we have the this is in the claimant's witness statement.
Yeah.
Paragraph 15.
This is for witness statement, right? Of Mr.
Yes,
ILYAS.
exactly.
Yeah.
We will take it up in that case.
Yes, before me.
So paragraph 15 following is where the claimant addresses various of the criticisms being made in relation to it. Before a paragraph, in relation to the original amended pleading, before a paragraph 25, setting out in detail the particular payments and the basis for them that are being claimed. And not only that, we'll see there that he relies upon, and he refers to it in paragraph 25, the contemporaneous documents evidencing these payments. And these are the ledgers that are enclosed at page 134 to 145, and they are at page 185 of the bundle. I won't take you to each one, but we can see at page 185 and following, copies of ledgers detailing monies being paid on the claimant's behalf. So in some detail. page 259, we have a witness statement from Mr. Saboowala's brother, who affected the payments, or some of the payments, on the claimant's behalf. And Mr. Sajid Saboowala supports the claimant's evidence. So in those circumstances, the basis for Deputy Chief Justice Steele's decision in relation to the claim for 6.85 million simply falls away. The basis upon which the payments were made by the claimant and or on the claimant's behalf are overwhelmingly clear from not only the face of the pleading, but supported by corroborating evidence, both from witnesses and the underlying documents. Furthermore, the legal basis for the claim is clear, and it's also clear how the contended payments were made, or how it's contended that they were made, under the SPA, and therefore falling within the terms of Clause 5, which was the original basis for not allowing the amendments, but also, quite clearly, for the purposes of Clause 8 of the agreement, being the jurisdiction clause. And my learned friend, I don't think, is contended that a claim for either enforcement of an entitlement under the contract, or indeed a claim for breach of contract, claim for damages for breach of contract, doesn't fall within Clause 8 of the SPA, i.e. the jurisdiction clause. Obviously, claims for breach of contract would fall within the parameters of that exclusive jurisdiction clause. So, to the extent that my learned friend wishes to make submissions in relation to the restitution claim or the quis claim, the primary basis upon which the claim is made is breach of contract. That obviously falls within the jurisdiction clause. I've already emphasised how the application is not made at a late stage. It's before pleadings have even closed. And in those circumstances, there is simply no prejudice that can be suffered that cannot be compensated for in costs. Perhaps I will leave my specific submissions, or the substance in relation to replying to those made by my learned friend, to reply, or would you like me to briefly just address them now?
I prefer after she submit, you can reply on her at once.
Very well.
Yeah.
I'll do that. So just to conclude, in all those circumstances, and particularly where the claimant's amended claim is so obviously good in law and has, at the very least, real prospects of success in the sense that it simply cannot be said that it is fanciful, where it's not made at a late stage, and where any prejudice suffered will be minimal and can be compensated in costs, and where the prejudice to the claimant is so obvious in being shut out from making a substantial claim for 6.85 million dirham, it's submitted that the court should take no other course than to allow the proposed amendment to the particular claim.
Thank you, Mr.
Your Excellency, before I commence, can I take a very short comfort break, literally minutes?
Okay. So, we'll come back.
5 minutes.
5 minutes?
Yes, I'm grateful.
Fine.
Thank you.
Otherwise,
Yes, Mr. Shah.
Your Excellency, before I address the criteria that my learned friend has to satisfy in order to get his amendments through, namely the test for an amendment, I want to set the tone for my submissions as by way of introduction, which is this. The bulk of the amendments stem from a claim for a repayment of 6.8 million dirhams. My learned friend is trying to persuade this court that these amount to expenses that fall within the SPA. We say not. And we also say that this was already dealt with by Deputy Chief Justice Steele in his judgment of February last year. Your Excellency asked the question of my learned friend at the start of his submissions as to whether or not it's the same issue. We say that it's the same relief that is being sought, and that relief was knocked out by Deputy Chief Justice Steele. However, it's being cast in a more, let's say, innovative way. However, the amendment still ought not to be allowed. And the reason is this. My learned friend said that there's no question that the DIFC court doesn't have jurisdiction. We say that that is the most critical issue that arises out of this amendment application. And to make that submission, my learned friend has completely misunderstood the SPA, the jurisdiction of this court, as well as Deputy Chief Justice Steele's judgment. And I will make good on all of that. However, by way of introduction, we say that the critical issue is whether or not the DIFC court has jurisdiction, whether the claimant's claim relating to the repayment of 6.8 million dirhams arises out of the SPA. If it does, clearly the court has jurisdiction. However, if it doesn't arise out of the SPA, then this is a matter that falls squarely and fairly in the jurisdiction of the onshore Dubai courts. The defendant's position is that it would be such that the test would not be satisfied, namely that there would be no prospects of success if this claim was allowed, that there would be real prejudice to the defendants if this was allowed, and also it would create complete disharmony of the jurisdictional regime of this court. And we say it's simply an opportunistic attempt by the claimant to try and shoehorn this claim for 6.8 million into the SPA. We say as a general point it would be contrary to the overriding objective. It may potentially open the door up to a Decree 19 judicial committee challenge. It may even force the claimant or the court to deal with merits in circumstances where the jurisdiction has not been properly contested and heard in a properly contested jurisdiction hearing. And that goes back to the point that Your Excellency made, whether or not there has been an opportunity to contest jurisdiction at the appropriate stage. We say it hasn't, and I will elaborate on that in the first part of my submissions. We also say that it may create an issue in terms of enforcement. Therefore, we say jurisdiction is a real issue that this court has to grapple with in order to do justice to the parties when coming to deal with whether or not the amendments fall within the remit of the agreement, the SPA, or outside it. Turning then, before I turn to the agenda of my submissions, can I very quickly address the test that this court has to apply? I'm going to turn to my learned friend's skeleton argument on this. As my learned friend submitted, there is no dispute between us in relation to the test. That's set out at paragraph 35 of the claimant's skeleton argument at page 15. And it's three matters that are raised there, three criteria: whether or not it's properly pleaded and has real prospect of success, whether or not there is any prejudice to the other party or parties caused by them can be compensated for in costs, and the public interest in the efficient administration of justice is not significantly harmed. If I can perhaps then turn back a page to 14, at paragraph 34, you were taken to the extract of the Cobbold and Greenwich judgment, and just where it's underlined, you've already been taken to that, but clearly there's a qualification as to when amendments should be allowed, and that is whether the public interest in the efficient administration of justice is not significantly harmed. And therefore, in terms of the agenda for my submissions, the first point I'm going to take is that the public interest in the efficient administration of justice point. And then I'm going to turn to whether or not it's been properly pleaded, prospects of success, and prejudice. And so therefore, Your Excellency, in terms of the agenda for my submissions, this is the form in which I'm going to take it. Firstly, deal with the efficient administration of justice, deal with the procedural difficulties in respect of jurisdiction, which will cause real prejudice to the defendant. That's the first part of my submissions. The second part of my submissions will deal with the re-amended particulars of claim, whether or not there are prospects of success, and within that category, the second sort of plank of my submissions, I will deal with subheadings, sub-submissions dealing with the way that the claim was put in the first particulars of claim, the POC 1, the way in which it was put in the second particulars of claim, which were the subject of the amendment application last January, why they were refused, I will then go on to deal with the re-amended particulars of claim that you have before you today. And we will look at, or rather analyse, the way in which the case is now being put, in that we will consider clause 2.6, clause 316, and how it should be construed, how clause number 5 should be construed, the indemnity clause, because my learned friend has attempted to connect all of those to try and make good the claim of 6.8 million, and we say that there is no connection, so we'll analyse those provisions. And then, Your Excellency, I'd like to deal with Deputy Chief Justice Steele's criticisms of whether or not the claimant has met those criticisms. We say the claimant has woefully failed in meeting those. And then we'll look at the other claims, the quid pro trust claim and the just enrichment claim, very, very briefly right at the end, depending on time. So that's the way in which I intend to take my submissions. So dealing with the first part of my submission, and that is whether or not the public interest in the efficient administration of justice is significantly harmed by reference to jurisdiction. We say it will be harmed, there'll be a real prejudice to the defendants which cannot be compensated in costs. The premise of my learned friend's argument appears to be based on an artificial construction of clause 2.6. And Your Excellency, I don't know if it's helpful to have the two documents that I will be consistently referring to. It's the SPA.
Okay.
Maybe it's, you could take that out. It's behind tab 8, which is part of the exhibit of the claimant's witness statement at page 173. So if you could just perhaps take that out and have it to hand. It's the bundle for this application.
Okay. Before me, give me a second.
Yes?
Okay, this is the one.
Page 173. If you could just perhaps take that out. And the second document that I will be referring to are the draft re-amended particulars of claim. You were taken to the clean version at page 13. I will, however, refer you to the black line version, which is at page 89. And again, it's behind tab 8 as an exhibit to the defendant's the claimant's fourth witness statement.
Yes, both is before me.
Yes, so perhaps just keep them out and keep them to hand. Now, dealing with the first issue, or the first part of my submissions, and that is the efficient administration of justice and whether or not it will be harmed. The company RAG is a company incorporated in onshore Dubai. It's governed by Dubai company law, and therefore we say any claim arising out of the administration of the company would properly be adjudicated in the Dubai court. So that would be the correct forum. Clause 8 of the SPA, it's on the last page, 182. It starts at 181 and 182. Clause 8 is what's termed as an opt-in jurisdiction clause. And my learned friend argues that this is a broad clause, and we say absolutely not. It only entitles the parties to deal with any differences or disputes arising out of this agreement. And what is this agreement? The dominant purpose for this agreement is the sale and purchase of shares in RAG Foodstuff. And we see that page 173, right at the top. That's the first three lines tell us what the dominant purpose of this particular agreement is. Now, my learned friend was referring to a point that we made, is that it's interesting and curious that nowhere in these re-amended draft particulars of claim do you see any reference to clause 8. My learned friend's explanation was that this was in the interest of brevity. We say that that's laughable when you look at the red line version, or rather the black line version, of the nature, the scope, the extent of the amendments. And we say that that was a deliberate omission because even the claimants recognise that it's construing clause 8 of this agreement too far and too wide. And again, I'll refer to evidence of that later. Now, if it's only claims that arise from the SPA, then we say that's the remit of the DIFC courts, and that's something, or rather the issue that Deputy Chief Justice Steele in his judgment also dealt with, and dealt with quite clearly and dealt with quite firmly. And therefore, if there is a dispute not relating to the SPA, such as corporate governance of RAG, it should probably go to the Dubai courts. Money lent to the company by a third party. So where Farmex is saying, well, look, I lent money to the company, that's properly a matter for the Dubai courts. Now, the way in which my learned friend has dealt with this by referring to a loan agreement, I will deal with that in the second part of my submissions. But in any event, the true parties to that claim, Farmex and RAG, two onshore incorporated companies, and therefore the proper forum for adjudicating that dispute is in the Dubai courts. Money held on trust, that would be a matter for the Dubai courts. Any restitutionary claims would be a matter for the Dubai courts. Any entitlement to profit, Dubai courts. Any injection of capital, and we say injection of capital does not form part of this agreement, and that will come when we analyse the clauses 2.6 and 316. That's properly a matter for the Dubai courts. My learned friend in his skeleton argument said, well, it can't go to the Dubai courts because there will be a multiplicity of proceedings. Well, this is a complex jurisdiction, and this court has already grappled with inter-emirate claims, and we know by reference to IGPL and Standard Chartered Bank that actually, and I consider that my learned friend is sort of arguing an FNC principle type argument. We say that those FNC principles aren't applicable where it comes to the DIFC or onshore Dubai courts, inter-emirate if you like. And furthermore, this court has dealt with cases wherein there are two concurrent proceedings. So the case of Corinth, there was a claim in the Dubai courts for return of monies, and then there was also a claim in the DIFC courts based on deceit and conspiracy, and therefore it's perfectly permissible for both claims, or rather two different claims, to be ran in DIFC courts and Dubai courts, based on the different legal tests and based on the different claims, and therefore we say that this court has already grappled with that, and we are not trying to shut out the claimant and trying to recover the money. What we are saying is that right or that entitlement arises in the Dubai courts, go to the Dubai courts. It's not arising as a matter of jurisdiction, as a matter of substance, as a matter of procedure. It does not arise out of the SPA, and therefore it should not be a matter for this courts to decide. Now, this is the claimant's third attempt, we say, in trying to amend his pleadings and bring this matter into the DIFC court. And we say that it's a cunning connection of these clauses in the SPA, an artificial construction that is being presented to you today. But if they are correct, and if this matter proceeds, and if the amendments are allowed, and if the matter proceeds in this court, then the defendant will have missed an opportunity to contest jurisdiction before even filing its defence. And I'm just going to take you through a bit of the procedural history. Now, if I can perhaps just go to the second bundle for the 3rd of January hearing. If I can invite you to turn to tab 2. So these were the first particulars of claim that were filed back in August 2017, if I recall correctly. 17th of August 2017. And I just want to very quickly, whilst we're at this document, look at two paragraphs, paragraph 36 and paragraph 61, because my learned friend's submission was that these two paragraphs heralded this claim, and we say, no, it didn't. If we look at paragraph 36 at page 10, now, this is quite important in terms of the facts as well. So the claimant worked hard for the benefit of the company, turning the company from a loss-making enterprise to one that made a profit of approximately £2 million in the financial year, January to December 2016. Now, pausing there for a second, what this is saying is that a profit was made year-end December 2016, and it could have only been a profit once the liabilities were deducted from the gross profit. And so we say that there was a profit there. So it's not quite clear how it is now being said that we need to recover this cash injection, because the cash injection, no doubt, ought to have been deducted from the 2 million. Leaving that to one side, between 11th of January and June 2017, the claimant injected working capital. So this is the first time we see reference to or characterisation of the monies that were paid into RAG. And it's a working capital. It's not described as an expense whatsoever. And approximately 6.8 million. And then it goes on to say what other monies were put in. So here we have reference to injected working capital, 6.8 million. And this is pleaded simply in the context of events after execution of the SPA. So if you go to page 9, it's under the title, Events After Execution of the SPA. I'm looking at page 9, the first particulars of the claim.
Okay.
Yeah, paragraph 31 to 36, under the title, Events After Execution of the SPA. So that's the context in which it's pleaded. Then if we turn to paragraph 61, my learned friend took you to this paragraph, but we say he didn't read it in context, particularly the sentences. We see 61, further alternatively, the claimant seeks further alternatives. This is an alternative case. Claimant seeks return of the monies taken by the first and second defendants under the law of obligations, including Part 2 and 8, on the basis that monies taken by defendants were investment monies held by RAG. So it's not saying we want these monies under the SPA, it's somehow trying to bring a claim under DIFC law. We then go on to say, or this pleading says, on trust for the claimant in relation to which the defendants owe the claimant fiduciary duties and duty of care which have been breached, again, not under the SPA. And or damages for breach of contract, that's not quantified, and or payment under clauses 1.1 and 2.1 of the SPA on the basis of the matters set out at paragraphs 30 to 55 above. Now, we say paragraph 36, which is part of 30 to 55, has no correlation whatsoever to clauses 1.1 and 2.1 of the SPA, because 1.1 and 2.1 of the SPA, if we look at it, deals with payments made for the purchase price in consideration of the shares of the business of RAG. Nothing to do with expenses, working capital, cash injections, and therefore we say that there's no reference to that 6.8 million claim there. And again, it goes on to read, to the extent that these are not included in the purchase price. Further alternatively, but it makes no reference to the 6.8 million. Further alternatively, the claimant relies on the indemnity clause to recover such amounts. The precise amount claimed under this head will be quantified with greater particularity following disclosure. Well, if that was referring to the 6.8 million as an expense to be recovered under the indemnity clause, then they wouldn't need to have further particularity, because at paragraph 36, it already states 6.8 million. And therefore we say there was never any intention for the claimant to pursue this part of the claim, 6.8 million, in the DIFC cause. And by reference to that, if I can also take you to Justice Richard Field's judgment, and you're already taken to this, it's in the 30th of January hearing bundle, behind tab 6, page 64. The claimant undertakes that any proceedings commencing the onshore Dubai clause dealing with matters arising out of the SPA will be discontinued forthwith. again, that's reference to the fact that the claimant understood that the 6.8 million cannot properly be part of the claim in the DIFC. Then we go on to sorry, if I can stay in this bundle, again tab 6, we're already here. We see at page 63, there's a further hearing in respect of this order, which is the order for an interim relief on the 10th of September 2017, and that was going to be the return date, as I understand. If we can then go to tab 7, this deals with Deputy Chief Justice Sir David Steele's order, and we can see the third paragraph from the top at page 66. There was an application for an adjournment of the return date hearing listed on the 10th and 11th of September, and we see an order at the bottom of paragraph 1. This was relisted 9th of October 2017. Over the page at page 61, we note there, provisions 3 and 4, that Deputy Chief Justice Steele gave orders for filing of a defence and counterclaim on the 21st of September and a reply on the 28th of September 2018. Now, the point here is this. Had this claim for repayment of the 6.8 million been made at that stage, then we would have said that we would like an opportunity to contest jurisdiction then. We weren't given that opportunity. We would have contested jurisdiction, and therefore, if this amendment is permitted now, we would say that because we have been deprived of the opportunity to properly contest jurisdiction in a properly contested hearing, it would offend the public interest in the efficient administration of justice. And we also say that it would prejudice the defendant in respect of being able to argue jurisdiction properly, and that's not something that can be compensated in costs. The reason being is this, because there'll be a whole trial then, a whole proceedings wherein the defendant hasn't been able to contest jurisdiction and will have to reserve its position in respect of jurisdiction later on, and therefore that's not something that can be compensated for in costs. And just to round off this point, if the court was amenable to the amendments, which we say it ought not to be, then there ought to be a provision whereby the defendant can properly contest jurisdiction, and therefore there ought to be directions for the defendant to be able to do that in a properly contested hearing before any further orders, directions are made for the progression of this case. So that's really the first part of my submissions. The second part of my submissions is in respect of whether or not the amendments have prospects of success and whether or not it's been properly pleaded. We say that the amendments in respect of the 6.8 million have no prospects of success. The first point is made that this is a properly pleaded case and it accords with RDC 17. We say that you only need to look at the nature and scope and the extent of the amendments to understand that that cannot be the case. That's the first part of the submission. The second part is that it's been advanced on a premise, an artificial construction of clause 2.6 in particular. It is connecting clause 2.6 with clause 3.16 of the SPA and therein clause 5, the indemnity clause. And we see that set out page 127 of the re-amended particulars of claim, the version that I've invited you to refer to, and paragraph 89.
See the pages?
127, paragraph 89. I'll take you to the rest of the paragraphs, but I think this paragraph is really a good illustration of what the claimant is trying to do here. It's trying to exercise the court in undertaking mental gymnastics of connecting clause 2.6 to clause 316 and clause 5 of the indemnity clause. And we say that those clauses stand completely separately, and there is no connection whatsoever in the way that the claimant has formulated and has invited the court to take into account. We've already looked at the first particulars of claim that was filed, and that's the August 2017 claim. The second version that was submitted for the court's consideration was in respect of the hearing of the 30th of January, and which was the subject of Deputy Chief Justice Steele's judgment of February. And the timing of all of this, clearly we're here at an anniversary event because it keeps recurring, but the same theme keeps recurring. The claimant simply wants to shoehorn a 6.8 million claim, and it cannot do that. It's impermissible under the remit of this SPA. And back on the bundle for the 30th of January hearing, if I can invite you to turn up tab 39, please. Yes. So tab 39, this was the amended particulars of claim that was before Deputy Chief Justice Steele. Tab 39. Deputy Chief Justice Steele on the amendment application that was being heard in January last year. Do you have that down, Your Excellency?
Yes.
You've already been taken to this document. I just want to point out to you paragraph 36 again, page 307. This is the same paragraph that that I've taken you to in the first particulars of claim, the August 2017, and we see that there has been no changes to this paragraph in that amendment application. We then, if we turn to 317, now you were taken to these paragraphs. I just want to highlight, for your benefit, Your Excellency, those paragraphs that were refused. So they were refused by Deputy Chief Justice Steele back last year. So that's 60C.4, page 317. And those were the sums that were being claimed. So that was refused. Over the page 318, 60C.5, that was refused. Reimbursement of monies paid by the claimant to Pharmex to ensure the supply of goods to the company made necessary by the first and second defendants refusing to sign cheques. And then it goes on to say about the funds that the claimant put into the company for the benefit of the company. That was refused. 60C.6, that was refused. This was monies also referring to monies put in by Pharmex. Now, Pharmex is a company that's owned by the claimant's brother, Mr. Sajid SABOOWALA. And one would describe it, or the defendants would describe it, at least a competing entity. So that was refused. 60.D, or 60D rather. The element that was refused in this paragraph is the second sentence starting. By reason of the said breaches of the contract, the claimant had incurred a liability for the monies advanced on his behalf by way of a loan by Pharmex. Namely, the sum set out, paragraph 60C.4.15 and 10, and 60C.6, has repaid 6 million of that loan and has paid the sums set out therein. So this is, again, the subject of this application. We see it rearing its head again, even though it was refused. 60E, the whole paragraph was refused, and that's the claim for restitutionary damages under the DIFC law. Turning then to the next page, page 319, 61A, the parts of this paragraph that were refused are starting just towards the bottom, where you see a strikeout. So the sentence above this, the sentences that are struck out, starting for that purpose, the claimant also seeks an account of the uses of the monies held by the company. Those were refused. And the reason why I'm taking you to these paragraphs is when we see the re-amended, the draft re-amended particulars of claim, you'll see how they are now being put. And actually, they are no different from what's been already put before the court. Now, let's turn to what was before the court last January 2017. And if I can invite you to turn up Deputy Chief Justice Steele's judgment.
Yes,
that's in the bundle for this hearing. I'm not going to turn to the other bundle now, so we're just going to be dealing with this now.
The judgment is before me. So can you find
Yes, the judgment, page 1. So it's page 1. And actually, it might be helpful to keep this judgment out as well, because I will be referring to it.
It's okay. Which paragraph of the judgment?
So this sets out the premise upon which they were refused, and you've already been taken through this judgment. But what I want to do is keep this judgment out, and then refer to the re-amended particulars of claim. So then we can do a sort of cross-check, a cross-comparison of what's now being pleaded and what was pleaded then. So, Your Excellency, looking at the draft re-amended particulars of claim, you can see the black line version. And, Your Excellency, just flicking through this document, which is the re-amended particulars of claim, Your Excellency. Do you have that there?
Yeah, I have.
Just flicking through that, it is unrecognisable as the claim that was first being brought back in August 2017, in the first version of the particulars of claim. It's a completely new claim. It goes from 62 paragraphs to 100 paragraphs, and only 3 paragraphs within this document are unchanged from the first version. What's the significance of this? The significance is this. We invited the other side to bring a new claim. And the reason why I invited the claimant to do that is so that procedurally this claim can be properly tested and can properly continue. So, for instance, we would then have an opportunity to contest jurisdiction in a proper application. However, the claimant's response to this was, well, we're entitled to do so. Their reading of Deputy Chief Justice Steele's judgment is that they have carte blanche to reformulate the claim to such an extent. And we say that can't be right, and that's not what was intended. And again, I'll address you on that after dealing with these amendments. Question, is it properly pleaded? That's part of the criteria for a test of amendment. We say that it falls foul of RDC 17.17. You will be familiar with it, but let me quickly bring it up just for reference. 17.
Statement of case.
Yes, I've lost it again. Particulars of claim must include a concise statement of facts on which the claimant relies, and then it goes on to plead how to plead quantum and interest. We say that this is far from pleading a concise statement of facts. It goes into excessive detail. It contains evidential material and argument, and that is something that Deputy Chief Justice Steele found offensive in the first round of amended pleadings. And I take that from paragraph 1 of Deputy Chief Justice Steele's judgment, in which he says in the second sentence, "It's perhaps not surprising that the cost is so high. Pleadings in this case, and particularly the statement of claim, are prolix, confusing and repetitive. They also contain evidential material and argument, and therefore there is no justification whatsoever in putting a pleading of this extent, of this nature, in a claim that's actually not even substantial. The value of the claim, it's completely disproportionate and offends against the direction given by Deputy Chief Justice Steele, as well as the rules." My learned friend took you through the various sections of the claim, Section A, Section B, Section C, and he referred you to a colour-coded particulars. We won't take you to that. Suffice it to say that my general submission is this: it's overly excessive, it's disproportionate, it's unnecessary, it's irrelevant, it's evidence, and it doesn't need to be in a statement of claim. And therefore, on that basis, there are objections. However, coming to the crux of the argument, the construction of the SPA argument, and why the claimant says it arises out of the SPA. The starting point there is page 97, paragraph 33.
97 of what?
97 of the re-amended particulars of claim. I'm looking at that now. So, as I've already stated, the intention of these paragraphs that I'm going to refer you to now is for the claimant to link 2.6 with 3.16 and clause 5. And before I go into the paragraphs, I just want to make this submission with respect to the SPA. Clause 2.6 stands completely independently to anything in clause 3. Clause 2.6 of the SPA is under a title Purchase Price and Other Related Payments. Has absolutely nothing to do with clause 3. What is clause 3? Representations and warranties of the seller. The purpose and effect of warranties stand independently and separate to clause 2. And clause 5, the indemnity clause, again stands completely separately, and that's how we invite the court to view these provisions of the SPA, quite independently of each other. So, sorry, I'm back to the re-amended particulars of claim. I will be jumping around a little bit. So, paragraph 33 starts with reference to clause 2.6, and we have no real objection to this because it, at paragraph 33, more or less accords faithfully and records faithfully clause 2.6. Our problem, or our issue rather, comes when we turn over the page to 98, and that's paragraph 34. So, paragraph 34, the first part of it, the 1, 2, 3, 4, 5, the first 5 sentences seem to be fine. When we go up to page 99, ending due diligence process, up to that point, we don't have any objection. However, this is where our objection comes. From that date, the financial needs of RAG, including cash injections, were equally to be met by the claimant under the SPA. What the claimant is attempting to do there is consider clause 2.6 and import into clause 2.6 the word including cash injection. And we say that's a complete misunderstanding, misconstruction of clause 2.6. Reading on, were equally to be met by the claimant under the SPA. Those words are just completely misconstrued, and we can see that if we look at clause 2.6 of the SPA. Clause 2.6 of the SPA, page 176, states this: It is agreed that any profit/loss made incurred out of any business activities conducted by the company under supervision of purchaser on and from the 1st of January onwards shall be fully received, borne by the purchaser only. The effect of this clause is that from the 1st of January 2016, which my learned friend described as the pivot date, that was the date when Mr. ILYAS went into the business as a caretaker. From that date, if there is any profit to be made, he can keep it. If there is any loss from that date, then he will bear that loss. And he will also bear the risk of that loss. That's what 2.6 is saying. It does not say what the claimant is inviting the court to include into this 2.6, including cash injections that were equally to be met by the claimant under the SPA. That wording is simply not there. It doesn't exist, and the way in which my learned friend is putting this is to say that somehow it should be implied, those words should be implied into Court 2.6 by necessity or by course of conduct or to give it common sense. And we say there is no basis upon which this court ought to imply those words into this particular clause, particularly because the words at clause 2.6 should be given their natural and ordinary meaning, the intention of the parties. And the intention of the parties was, I will take, and the claim was that the claimant will take the benefit, take the profit, and will also bear any risk whilst he is operating the company. That's the only commercial sense that you can give to clause 2.6. And also, clause 2.6 has to be read in the context of the agreement and the dominant purpose, the primary obligation of the agreement, which is share purchase, a transfer of shares for a purchase price. And just on that point, if I can invite Your Excellency to refer to Demand Park Towers, which is a judgment of this court, and I don't think you have that to hand us yet.
Oh, not an authority bundle?
It's not in the bundle, no. And Your Excellency, you were in fact in the court of first instance, you were presiding over that case. You might recall our friend Mr. Ward. And part of this case. Yes, the issue was construing the reservation agreement, you'll remember. And what the court said in the Court of Appeal starting at page 15, it gave us principles in terms of how contracts ought to be construed in this jurisdiction. We start at paragraph 79, and it was talking about Mr. Ward's payment obligations and the reservation agreement. The parties have advanced competing constructions of the payment schedule, and it falls on this court to determine its proper construction in construing the reservation agreement. This court will be guided by Article 49 of the IFC contract law, which defines the nature of the exercise. Article 49, intention of the parties. Common intention of the parties is Part 1. Part 2, if such an intention cannot be established, the contract shall be interpreted according to the meaning that reasonable persons of the same kind as the parties would give it in the same circumstances. Pausing there a second, my learned friend made a submission about there being no evidence as to what the intention was. My submission, and I hope I've reflected that correctly, but my submission in response is that a matter of construction isn't reliant on evidence. It's reliant on the words and the natural and ordinary meaning of the words. You don't come to court and you don't have the party to say, well, I thought that the agreement meant this, because that's not very helpful to the court. What the court has to do is look at the words, construe those and interpret those in line with what it envisages the common intention of the parties would be, and also what the plain and ordinary meanings of the words are. Going back to Ward, paragraph 80 talks about how a contract shall be interpreted according to the common intention of the parties. When disputing parties that jointly put forward an interpretation of the contract. 81. Since the parties disagree on the proper interpretation of the reservation agreement, it is Article 49.2 that applies, in providing that a contract shall be interpreted according to the meaning that would be ascribed to it by a reasonable person in the party's position. Article 49.2 mandates that the inquiry should be an objective one, and this goes back to my point. There is no requirement for evidence. It is an objective analysis for the court in circumstances where there are two conflicting interpretations for the court to determine what the words mean, or what they would mean to a reasonable person. Paragraph 82, it's reference to investors' compensation. Paragraph 83, there's reference to the contract law, and a case is provided, and there's a dicta to that case. Often there is no obvious or ordinary meaning of the language under consideration. There are competing interpretations to be considered. In choosing between alternatives, the court should primarily be guided by the contextual scene in which the stipulation in question appears. And speaking generally, commercially minded judges will regard the commercial purpose of the contract as more important than the niceties of the language. And we then, my submission is that the commercial purpose was the sale of shares, and the commercial purpose is something that was considered by Deputy Chief Justice Steele, and his conclusions on that, which I will return to. Paragraph 84, the dicta in Rainy Sky is provided for, and underlined, if there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and to reject the other. And so therefore we say the commercial business common sense of clause 2.6 is as set out in clause 2.6. There is no reason, no basis whatsoever for the court to somehow parachute in language that the claimant is inviting you to do so in respect of that there was an obligation for cash injections. There is no obligation under 2.6 for the claimant to make cash injections. It's simply not there. Going back then to the amended particulars of claim, paragraph 35, 35.1, it was envisaged that the claimant would incur expenses in for RAG pursuant to the SPA. That's reference to clause 3.16, although it's not set out there, and it's deliberately not set out there because 3.16 is a warranty clause, and I'll come to what the effect of a warranty is. 35.2, such expenses would include not only losses incurred by RAG from the 1st January, which were to be borne by the claimant, so accepts that, but also any sums advanced to RAG by the claimant or on behalf of the claim, or on the claimant's behalf pursuant to clause 2.16. Again, 2.16 just simply doesn't say that. That's a considerable stretch of 2.6, an overstretch of it. It's simply not there. So if the effect of clause 2.6 is that the claimant will bear the risk of any losses, and that must also include working capital, the injection of cash, the injection of working capital, and therefore you cannot then somehow make a quantum leap from working capital, cash injection into the company of his own volition. Nobody asked him to do that. He did it himself, and therefore from the 1st of January, he bears the risk of that. You cannot now say suddenly that actually these are expenses, which I can claim under the indemnity. That's not giving this SPA commercial business sense. Paragraph 38 then of the amended particulars of claim. Again, our objection is this. Accordingly, as referred to paragraphs 34 to 35 above, pursuant, and objection starts here, pursuant to clauses 2.6 and or 316, that's where the connection is, and or otherwise pursuant to a term implied into the SPA. Again, there's no reason for an implication of any sort of term. either for business efficacy or because it's so obvious, because it's not obvious. Through at 38.1, from the 1st of January, the claimant was obliged and or expected to make payments on RAG's behalf and or otherwise inject funds into RAG for routine business activities. There is nothing within the terms of the SPA that expressly state that the claimant was obliged to put in cash injections. As I said, he did so of his own volition. You cannot read that into clause 2.6. It's simply not there. And that's what the claimant is inviting you to do. And if you do allow that, we say that that impinges on the jurisdiction of the Dubai courts, and it's not a jurisdiction, or it's not a claim arising under the SPA. Next paragraph 48. So this is quite interesting. If you look at pages 102, 103, I mean, you see complete swathes of the pleading just deleted. And this demonstrates the extent to which this claim has been recast, reformulated, re-engineered to make it a completely new claim. So 48. You've already seen this paragraph. This was the old paragraph 36, and this is in respect of the profit made. Again, I make the point, working capital or cash injection is a liability that would need to be deducted from a net profit figure, and therefore if he's made 2 million, then it raises a question as to where the 6.8 million is coming from. So that's really a side point. Paragraph 50. Accordingly, pursuant to his obligations and responsibilities from the 1st of January, pursuant to clause 2.6, there is no obligation, there is no responsibility whatsoever in clause 2.6 for any injection of cash. It simply states an entitlement of the claimant that he can take the profit that he is responsible for, because he's a caretaker of the company from the 1st of January, but that comes with the risk, a risk as well, and therefore he has to bear the risk. So therefore, no obligation, responsibility. Moving on, and 316 of the SPA, and or otherwise referred to at paragraphs 33 to 35 and 38 above, the claimant injected working capital into RAG for the specific purpose of paying RAG creditors for routine business, 6.85 million, so forth. We say from accordingly to further detail below should be struck out, no permission should be granted, because there was simply no obligation to inject cash, and the whole premise of that paragraph is the artificial construction of clause 2.6. Paragraph 51. We saw this in the pleading that was before Deputy Chief Justice Steele. Deputy Chief Justice Steele simply didn't allow permission for it, refused it, and we see it back here again. Paragraph 52. So it's clear here that it's Sajid SABOOWALA, through Farmex, who pays 165,000 to RAG. This is a claim against the company by Farmex. Similarly, 52.2, it's a claim by Farmex against the company. The proper forum is where the companies were incorporated, and that was onshore Dubai. Paragraph 54, again, it's the same submission that's made there. And then, if I can just give you for your reference, paragraphs 56, 61, 88.2, 88.3 and 89, again we say that this is a complete distortion of clause 2.6, and you have my submissions about clause 2.6. It should be construed, given the words, their ordinary and plain meaning. Then that takes us to paragraph 89, which we've already seen. And this is where the claimant is attempting or inviting the court to draw a connection between 2.6, 316 and indemnity. And we say that there is no connection. There is simply no connection. in order for there to be a connection, what the court must first do is imply into clause 2.6 the words that there was an obligation by the claimant to inject cash. It cannot imply those words, and therefore it's not necessary, it's not obvious, and therefore there is no persuasive reason as to why the court ought to imply those terms into clause 2.6. That leads me on to clause 316. 316 in the SPA, I'm just looking at it now, it's under the heading Representation and Warranties of the Seller. Starts at page 176. 316 itself is at page 178. It's Roman numerals XV1, starting, the sellers confirm that they will fully cooperate.
Yeah, it's a bit one.
Yeah. And before I get there, my learner friend referred to 13 as well. I think the only point to be made there is that it gives reference to the 31st of December 2016, or the 1st of January 2016 being the date upon which the claimant was to go into the business. Sellers agree to fully indemnify, compensate the purchaser of any claim, damages, litigation brought against the purchaser of the company, accruing on account of any acts of the sellers the company on or before the 31st of December 2015. And therefore, what the sellers are saying, look, we're happy to indemnify you, compensate you up to the 31st of December 2015 point. After that, the 1st of January 2016, it's yours. You take the profit, you bear the risk. You want to inject working capital? A matter for you. But it's not representative of what the parties agreed under the SPA. Turning to 16 then. My learned friend relies on this to say, well, actually, this is the clause that firmly entitles the claimant to all expenses incurred by the purchaser from the 1st of January in/for the company, and therefore that gives rise to a claim of indemnity under clause 5. We say that's a complete misunderstanding of the nature of a warranty clause. What is a warranty clause? We say it stands independently for a start from clause 2.6. We also say that it is trite law that a warranty in itself, generally, is an assertion by a seller on the date of execution as to the status of the company. That's what a warranty does. It's relevant to the date of execution. And so, what is the date of execution here? The date of execution is the 8th of February 2016. It's a month and some days after the 1st of January, the pivotal date, the date in which the claimant came in and took care of the company. If that is right, and if the specific purpose is to determine the state of the company, the specific purpose of the warranty is to determine the state of the company at the time of execution, then that gives sense to this clause. And how does it give sense? If it's read in this way. In such an eventuality, all expenses incurred by the purchaser from the 1st of January in for the company shall be returned by the seller. What it's talking about here are those expenses incurred from the 1st of January to the date of execution, which is the 8th of February 2016, which we would say is the warranty period. That's the period of warranty, and it's in that period that these warranties apply. Yes, if there is a breach of the warranties in the warranty period, it's a claim for damages, and that gives rise to a claim under Clause 5. However, you cannot say, oh look, I'm putting money in, that amounts to an expense, and I can claim it under a warranty clause. That's not how warranty clauses work. And we say that the interpretation that we put, that the defendant has put on 316, which I just submitted, makes commercial sense, and therefore it cannot be about cash injection. And that reading gives effect to clause 2.6. The court doesn't have to then start implying terms into clause 2.6. 2.6 is clear. You come into the company 1st of January, you're going to bear the risk, but you take the profit. Stand separate. 316, there's a warranty period. The warranty period is from the 1st of January to the date of execution of the agreement, 8th of February. Within that time, if you have incurred expenses such as instructing auditors, instructing solicitors, go to the notary public, all of these would be expenses incurred in the warranty period, and you can claim for them. That would be within the remit of clause of this SPA. However, cash injections, working capital is not. That's not a claim that can be recovered here. They should go to the DIFC, the Dubai courts. You were also referred to by my learned friend to clause 2.5, and what my learned friend said was, look, 2.4, you see at the last part of that clause at page 176, you see there being a theme of expenses. Well, there's a couple of observations I have about that submission, and that is this, that it's talking about a time when a purchaser will only reassign the trademarks, and that is if all expenses incurred are returned to them. Now, it's talking about expenses from the 1st of January, but if that is to be linked to 316, then again I go back to the point that it's only in relation to the warranty period. Expenses is not defined in this SPA, but it cannot be stretched to cash injections or investments made by the claimant of his own volition because he thought he was going to make a profit. That's not part of the SPA. In any event, it also states this payment shall be made within 1 month of written demand from the purchaser. As far as I understand, there has been no written demand for these payments. So, to conclude this part of my submission, we say that there's no obligation for a cash injection provided for in clause 2.6. Cash injection was at the claimant's own risk, sits outside of the SPA, and therefore properly a matter for Dubai courts. And if the court severs the purported or the artificial link that the claimant is trying to create between clause 2.6 and 316, the effect of which will be that there was no obligation to inject this money, and therefore it stands outside of clause 5, the indemnity clause. I then want to very quickly deal with how Deputy Chief Justice Steele dealt with these matters at the hearing of 30th of January. So, paragraph 1 we've already dealt with in terms of this is not a properly pleaded case. Paragraph 3. The basis of the bulk of the controversial amendments is the second numbered clause 5 of the agreement, which contains the indemnity provision. You've already been referred to the indemnity provision. It's cited there by the judge. Paragraph 4. This indemnity provision has to be read against the background of the primary obligation of the agreement. So in this context, and by reference to the Court of Appeal judgment award, the primary obligation is for a sale of the shares in a business. Simple. It doesn't go beyond that. And it's stated here, namely the transfer of the shares to RAG by the defendants in exchange for a prescribed purchase price. Nothing about injection of cash. Indeed, the claimant sought a mandatory interlocutory judgment in that regard, which was refused by the court. Then we go on to paragraph 5. And this is where the judge refers to paragraph 36, which we've already seen, and which my learned friend is trying to argue heralds this claim. Between 11th of January 2016 and June 2017, the claimant injected working capital into RAG of approximately 6.8 million. So it's in relation to the 6.8 million that is the subject and the concern of the defendants in this application. Paragraph 12, if we go to paragraph 12, and this is where Deputy Chief Justice Steele gives his interpretation of this clause, clause 5. As an indemnity provision, it is in relatively standard form in two parts. The first part requires the sellers to refund payments made by the purchaser by way of the purchase price under clause 2. When in breach of the agreement, this is not relied upon. The second part requires the sellers to indemnify the purchasers and its officers in respect of losses sustained by reason of the seller's breach, together with payments made by the purchaser under the agreement. Whilst the clause may be broader than furnishing protection against third-party liability, it would not appear to be concerned with payments made outside the scope of the agreement. So if this court construes clause 0.26 as the defendants invites it to, then we say that those payments, the 6.8 million, are outside the scope of the agreement, as already stated by Deputy Chief Justice Steele. Paragraph 13. As already noted, the sums which form the heads of claim in the proposed amendment are in large part not payments under the SPA, but are advances made by Farmex to RAG by way of a loan, together with payments by the purchaser in repayment of the Farmex loans and or in conduct of RAG's business. The whole section of the claim is almost devoid of particularisation. Now, this is where my learned friend says, oh, well, we've satisfied that criticism because we've got evidence now. And I'll turn to the evidence, but we say there is no evidence still before the court. But just dealing with what Deputy Chief Justice says. But if that analysis was correct, so let's say, even if the court accepted that the claim for the loan by Farmex was properly particularised, what Deputy Chief Justice Steele is saying, they would not be claims which can be pursued under the indemnity. Indeed, they would not on the face of it be claims falling within the jurisdiction of this court. It is only in respect of claims arising from the SPA that the parties have opted into the jurisdiction of the courts. So we say if there is no extended obligation of clause 2.6, and 3.16 only concerns itself with expenses during the warranty period, the correct form in which to bring this claim for 6.8 million is the Dubai clause, not the IFC clause. I then want to turn to very quickly sort of the evidence point. So,
Still going? I mean, you have a lot?
No. This is very, very quick. Very quick indeed.
But if you have, I can adjourn for lunchtime and we can resume after that. I don't want to...
No,
up to you.
Would you like to adjourn now, or...?
Up to you.
Okay, well, let's adjourn for lunch then, perhaps, and then I can deal with the rest of my submissions. I think it's just going to be a matter of about 10 minutes anyway, but it's either we can continue.
Again, the claimant, you need more than 10 minutes?
There are a few matters arising, but yeah, I will need more than 10 minutes.
So then we'll adjourn for lunchtime. We'll resume at 2
I'm
p.m.
grateful. Thank you.
Thank you.
All right. Definitely, Your Excellency.
Yes, Ms. Bashar.
So, Your Excellency, I dealt with the clauses in the SPA and how they ought to be construed. Turning then to the other criticisms that were raised by Deputy Chief Justice Steele in his judgment the first time round, he raised criticism in relation to the evidential difficulties that the amended particulars of claim had last year and at that stage. And I'm going to submit to this court that actually, even on this occasion, the claimant has not made good on those criticisms, and evidentially this claim has failed to demonstrate prospects of success. Now, I say this and I couch it with the qualification that it's not for this court to conduct a mini-trial, and I'm not inviting it to. But it is for this court to understand the documents and what they say on the face of the documents, and it's quite clear the documents speak for themselves. In terms of the evidential difficulty raised by Deputy Chief Justice Steele, if I can invite you to turn to paragraph 6 of his judgment. So he records proposed paragraph 60C, and you'll recall when I took you to particulars of claim 2 that this was refused. Paragraph 60C sets out the amounts of some 10 payments made to RAG or otherwise incurred by the claimant. The bulk of them were in fact paid by Farmex, a company owned by the claimant's brother, by way of loan to the claimant. The claimant has, it is suggested, repaid Farmex 6 million of those loans. Some of the other payments are said to have been made by the first defendant, but repaid from the funds of the claimant. Yet others were made by Sharisi to Rice Mill, presumably to the first defendant, but repaid from the claimant's funds. A further head of claim is said to be made up of monies paid by the claimant to Farmex to ensure supply of goods to the company. So paragraph 6 sets out the claims as pleaded at that point. The criticism follows thereafter in paragraph 7. This is but a rough summary of the claim for an indemnity. It is a matter of some concern that apart from the assertion in the claimant's witness statement, there is no documentary evidence of the making of any loans. And that distinction is important because my learned friend seeks to argue, well, we do have evidence because Mr. Sajid, the brother, has provided a witness statement. But actually, not only is Deputy Chief Justice Steele talking about witness statements, but he wants to see documentary evidence. And at present, there is no documentary evidence of the making of any loans by Farmex. And reading back then paragraph 7, let alone of the terms on which they were made or repayments received. So documentary evidence, terms of the loan, and repayments received. That's the sort of evidence Deputy Chief Justice Steele is looking for. Nor is there any witness statement from the claimant's brother. But in any event, it does not appear to be alleged that the loans or any repayments were made under the terms of the SPA. And so we say that this is the measure by which documentary evidence, or rather evidence, supports that claim. So where is that claim pleaded at the moment? It's at paragraph 14 of the SPA, of the redrafted particulars. And I'm looking at the amended particulars again, page 91, paragraph 14. And this is how it's pleaded. In circumstances where, as explained above, the claimant did not have a bank account with UAE, it was envisaged by the parties that the aforementioned payments would be made by Farmex or Mr. Sajid personally on the claimant's behalf. It was also agreed that cheques would be issued in favour of RAG and not in favour of the first and second defendants in circumstances where RAG had outstanding liabilities in the sum of approximately 17 million. Now, this is the important part of it. The claimant had entered into an oral agreement with Sajid that he, Sajid, personally or through his company, Farmex, would make payments on the claimant's behalf and the claimant would reimburse him or Farmex as appropriate as and when he was able to. And what we say is that's not sufficient for a pleading to plead terms of a contract. An oral agreement is a contract for a loan. There are no terms set out in this pleading, and therefore this pleading fails on that basis, that very simple basis. Turning then to the witness statements that have been provided. The fourth witness statement in support of the application is at page 44, and that's just for your reference. We don't need to turn it up because the submission is simple. We say that there is no evidence, even in that witness statement, of the terms of the loan on a contractual basis, on a contractual analysis of this. We then turn to the claimant's fifth witness statement, which was given in response, and I would invite Your Excellency to turn that up. It's at page 382. Paragraph 21 at page 385. And I'm looking at the last sentence of paragraph 21. For the avoidance of doubt, I have never maintained that the payments made by Farmex...
Excuse me, Miss...
Yes.
Which page? 300?
Page 385.
85?
Yes, my apologies.
And paragraph?
21.
Yes. And
it's the last sentence starting. For the avoidance of doubt, I have never maintained that the payments made by Farmex were loans to RAG. Farmex is not and has never been a financier. 22. without waiving privilege, I understand that if Pharmex had made loans to RAG, then the recovery of those loans would need to be the subject to a claim in the Dubai courts by Pharmex, and the DIFC courts would not have jurisdiction over such a claim. Contrary to what is alleged here, and contrary to what is being asserted at paragraph 14, we say that on the face of the documents, it was precisely monies by Pharmex to RAG. That's exactly what was being done here. And I can make good that if I can just invite you to turn at page 185 of the bundle. This is attached to the particulars.
One
185. So these are the documents attached to the particulars.
Yes, I saw.
Right. So we see reference to what these are in asterisks. Amount invested by ILYAS. So it doesn't say expenses, it says an investment for petty cash. Number 2, funds transferred from Pharmex. So actually it was Pharmex who transferred the funds. It wasn't Pharmex, ILYAS, and then into the company. Defendant submitted this voucher, Pharmex proceedings in Dubai courts. So Pharmex has already, or at the time that, bless you, at the time that the claimant filed its proceedings back in August 2017, there were proceedings on foot in the Dubai courts, and Pharmex had brought those proceedings. Page 86 over the page. Amount invested by ILYAS GAFFAR. So again, it's an investment. These aren't expenses. They don't form part of clause 2.6. There was no obligation for ILYAS, the claimant, to invest this money. And then again, we see second asterisk, funds transferred from Pharmex. So it's quite properly a claim by Pharmex. And if so, it should go to the Dubai courts. Page 187, again we see amount invested by ILYAS, same submissions, funds transferred from Pharmex. Page 188, same description given to those monies, an investment, not expenses. Page 190, again, we see the same description being given. Goods received by RAG, we see the third asterisk. We say that this is not part of the SPA. It doesn't go to the dominant purpose, the primary obligation, which is the sale of the shares for consideration. Page 191. Payment to supplier against purchase of goods. Funds paid by Sajid to supplier on behalf of ILYAS. But again, this is a claim by Sajid if it's to be properly made.
So far, no cases before the Dubai court, right?
There were cases made in Dubai courts, but those have either been discontinued or they've run their course, I think. Yes, they've run their course, yes, as far as I understand. I'd also like to take you to the Memorandum of Understanding that was entered into by the parties, and this is at page 278. Now, I understand and I accept that the SPA supersedes this MOA for sale and purchase, but it's interesting to note what was provided for to make an objective analysis of the common intention of the parties when they entered into the SPA. If I can invite you to turn to clause 5 of this document, page 281. So this is under section 3, clause 3, representations and warranties. So this is a warranty in the MOA, and it's the top of page 281, a Roman numeral 7, B11. Seller hereby confirms that there exists no contractual or any business obligations of the company with any of the parties except that it is acknowledged by the purchaser in writing as on the date of signing of this agreement. This goes to the point that I was making, that a warranty is an assertion of a position at the time the agreement is executed. So at the date of signing this agreement, seller shall be fully liable of such obligations whatsoever, and seller agrees to fully indemnify purchaser of any claim, damage, litigation brought against the purchaser. The seller also confirms that he shall be fully liable to recover amounts on accounts receivable booked till the 31st of December 2015. So it's clear that it was only the seller was agreeing to only be liable up until the point of 1st of January. After that, it's the claimant who bears the risk and retains the profit. And it's interesting at this point, just to pause, because if you were to accept the claimant's construction of the SPA and stretch clause 2.6 in the way that you're invited to by the claimant, then the effect of that would be that not only would the claimant take all the profits, but he would also recover everything that is paid in. I mean, that does not make good commercial sense. And so therefore, we say that should be a point dissuading this court from accepting the construction placed by the claimant. Turning then to page 289. So this is one element of the money that's part of the 6.8 million. It's a cheque dated 30th of July 2016. It's a cheque made out to RAG on behalf of Farmex. And so we say quite properly this is a claim by Farmex against RAG. And the loan element not only is a red herring, but it hasn't even been pleaded properly. There's no documentary evidence about it at all. Page 290. Again, we see investment in RAG, and it says loan, but again, there's no terms that have been pleaded. Mr. Sajid SABOOWALA, the brother, has given evidence, and I think that's to satisfy Deputy Chief Justice Steele's judgment when he said that there ought to be, or he invited, should I say, or rather commented that there should be a witness statement. There's no witness statement. The witness statement from the claimant's brother, if I can just invite you to turn that up, is at page 259.
Yes.
Starts at 259, and he sets out sort of a broad description of why the monies were lent and so forth. But again, that hasn't been pleaded in the pleadings. So whether or not it's in the witness statement is neither here nor there. However, the important point here is if one goes to 262, top of the page, above 18, it says, last sentence, for the avoidance of any doubt, I confirm that Farmex has received 6 million back from ILYAS to date in settlement of the funds. Again, there is no documentary evidence of that before this court whatsoever.
But this, what the statement was before Justice.
No, it wasn't. No, it wasn't. But if we go back to paragraph 7 of his judgment, Deputy Chief Justice Steele is talking about documentary evidence, making of any loans, the terms, or repayments received. So he's looking for documentary evidence. There is no documentary evidence, and therefore we say the loan is a red herring. And actually, on the face of the documents themselves, I mean, for instance, there are other checks here. If one goes to page 289, for instance, RAG, Farmex has paid a check to RAG. 313. Sorry, 314. These are payments being made by Farmex to a third-party company. 315, again, payments made by Farmex. 316, 317, these are all payments made by Farmex. And we say that they have no place for a claim under the SPA. That's on the face of these documents. And therefore, to say now it's a loan that's not properly pleaded, no documentary evidence, is simply a red herring, and further, it doesn't satisfy the dicta of Deputy Chief Justice Steele's judgment. In terms of the reformulation aspect, my learned friend has submitted that, in fact, we were invited to draft the pleading in the way that we have now drafted, and actually everybody understood that we would be producing a document of this nature. And we say that that's a misunderstanding, in fact, of what happened at the hearing in front of Deputy Chief Justice and what the parties understood was the situation. Turning then to, again, Deputy Chief Justice Steele's judgment, paragraph 11. Last sentence. To call this confusing is, if not incoherent, is an understatement. And again, we say that to import words into 2.6 and to somehow invite the court to connect 2.6 with the warranty clause, with the indemnity clause, is still confusing and incoherent and is bad in law. Paragraph 14. What is it, in fact, that Deputy Chief Justice Steele is actually saying? What he is saying at 14 is that the pleading as a whole is fairly incoherent. It is tempting to require the whole document to be reviewed and reformulated. So he's saying it's tempting to do that, but he in fact doesn't go as far as doing it, nor does he go as far as inviting the claimant to completely recast its case. Certainly the claimant should review the pleading in light of the difficulties and inconsistencies outlined above. Well, we say it is still the claim for 6.8 million is still difficult. It's still inconsistent, particularly when read with paragraph 3, the indemnity clause, and paragraph 12 of Deputy Chief Justice Steele's judgment. So, 14, reading on, paragraph 14, any amended formulation must be expressed in a form in compliance with the rules of the DIC court, should be adequately particularised and be supported by appropriate evidentiary material. It's not in compliance with the rules of the DIC court. I've already referred to 1717 RDC. It's not adequately particularised. There's nothing about the terms of the loan, and there is no appropriate evidentiary material in the form of documents. My learned friend referred you to the letter written by KBH at page 496 in an attempt to persuade you that, in fact, the claimant has or had carte blanche to put in a new claim. We said that doesn't accurately reflect what the position of the defendant was in that letter. Page 496. What it does at paragraph 3, what it in fact invites the claimant to do is put in a coherent and evidentially supported case in respect of the Farmex payments that fall within the SPA, not these claims that are made outside it, and the jurisdiction of the DIFC court. And we say there is still, the invitation is qualified that any claim must be part or must be within the jurisdiction of the DIFC court. And finally, if I can just address you very quickly on the amendments in relation to paragraphs in relation to the quist close trust claim that's being made at paragraph 90 of the amended particulars of claim. Paragraph 27 of our skeleton argument deals with this, and rather than take up too much of the court's time, we will invite Your Excellency to read paragraph 27. Effectively, the point that's being made there at paragraph 27 is that the principles and the parameters necessary to establish a case of quist close trust have simply not been met, and therefore there are no prospects of success. Again, this is an entirely new claim, doesn't arise out of the SPA, because it relates to the 6.8 million dirhams, and therefore that should be also struck out or not permitted. Then the case or the claim made for unjust enrichment, paragraph 91 of the revised draft. You'll note from the amended pleading that was before Deputy Chief Justice Steele, he already dealt with this, and I've already referred back to you, and I can take you to it again, but you have the reference, and we say that, again, if it arises out of the 6.28 million, then it should not be within the remit of this court. In terms of the mediation costs, we say it's not properly part of a claim for damages, because effectively what, as we understand, what the claimant is saying is, had the parties entered into a mediation, then they would not need to commence court proceedings. But for the failure to participate in mediation, we say that that does not give rise to a claim for damages. If they have been forced, which we deny, but if their claim is that they've been forced to commence these proceedings, if they are successful, then they'll clearly be awarded their costs of the proceedings. So they can't have damages as well as costs of proceedings. That would amount to double recovery, and therefore we say that that would not be allowed either. Claim for consequential losses, I think that's the same submission. And so finally we say, in conclusion, to conclude my submissions, number one, there's an artificial construction of 2.6, clause 2.6 of the SPA, that's being relied on. The words should be given their ordinary and commercial sense in accordance with how contracts are construed. Clause 2.6 is completely separate to the warranty clause, and in terms of the warranty clause, as I said, it's trite law that those warranties apply at the time of execution, and so therefore that would be, the warranty period would be 1st of January through to the 8th of February, and that's where the expenses claim arises, and should not be confused with working capital or cash injection. It's outside the remits of the SPA. If allowed, we say, if these amendments are allowed, then it would be a procedural nightmare, and it would cause real prejudice to the defendant, because the defendant hasn't had a proper opportunity to contest jurisdiction in the ordinary way. And the loan, we say, is a red herring in any event. It hasn't been properly pleaded. There is no documentary evidence of any circumstances surrounding this purported loan, not least that there is a liability, because there's no evidence before you that these monies have been paid, and therefore this application ought to be dismissed. In respect to the two cases that my learned friend referred to, he referred to the case of Orion in support of his application, and Christos Papadopoulos. In both those cases, I was counsel, and we say that those cases can be distinguished from the present case. In the Orion case, the parties, or rather it was a case arising out of a liquidation. The liquidator was based in the DIFC. The companies were incorporated in the DIFC, and the DIFC had therefore correct jurisdiction under the Judicial Authorities Law, and therefore it was right to allow that amendment. There's a clear distinction here in terms of jurisdiction. As to the Christos case, we say that the distinction was that, unfortunately, the claimant was deceased there, and therefore I think the court took a very pragmatic view in terms of progressing that particular case. That's not to say that there are prospects of success in this case, and therefore it should be allowed. We say the application should fail because of jurisdiction. In terms of costs, I won't address you. I would just perhaps submit the approach that we would invite the court to take, and that is that the court invites written submissions on costs if appropriate to do so. However, if the amendments are allowed, then the defendants ought to get their costs of an occasion by the amendments as the usual order in the normal way, number one. And number two, also the court should consider whether or not procedural directions should be given for a contested jurisdiction hearing. Your Excellency, unless there's anything else that I can address you on, I'll leave my submissions there. I'm grateful for your time. Thank you.
Thank you, Ms. Bashir.
Thank you.
Yes, Mr.
Your Excellency, I do have a few points that I'd like to address to you on arising out of those submissions. The first one concerns the reference to Farmex and, as my learned friend puts it, the red herring of the loan. Indeed, it is a red herring. It's a red herring that my learned friend spent a lot of time and a lot of effort in relation to her submissions on. It's a red herring to the claimant's claim, because that's not the basis upon which the claim is put in the particulars of claim, as will have been apparent from paragraph 14 and 43 of the particulars of claim. I think it's important that the court is clear as to how it is put. If we could turn up page paragraph 14 of the re-amended particulars of claim, which are at page 15 of the bundle. Paragraph of page 15 of the bundle. And we'll see there that what is being referred to here, and the basis upon which this paragraph is done, is in relation to the payments of the purchase price, the initial payments of the purchase price. This is the context in which this arrangement between the claimant and Farmex and Mr. Sajid SABOOWALA is described. So if we read paragraph 14, in circumstances where the claimant didn't have a bank account, he arranged for Farmex and or Mr. SABOOWALA, Mr. Sajid SABOOWALA, to make the payments on his behalf. This is in relation to the purchase price, as we'll see it at paragraph 15, where it's described how payments were made by Sajid SABOOWALA on the claimant's behalf in relation to the amount due under the share purchase agreement. Now that forms part of the claimant's claim, the recovery of those amounts paid due under the purchase price. My learned friend makes no objection to the fact that these payments were effected by Farmex and or Mr. SABOOWALA. There's no question that the payments of the purchase price were made on the claimant's behalf. And yet, my learned friend opportunistically takes the inconsistent position to try and maintain that there is something undue or inappropriate about the way in which subsequent payments were made on the claimant's behalf by Farmex and or Mr. SABOOWALA, Mr. Sajid SABOOWALA himself. And in my submission, on that basis alone, the defendant's argument in that respect should fail. They can't, on the one hand, accept payments made by Farmex on behalf of the claimant, and then, on this, in another aspect, when it suits them, to say, well, actually, no, they weren't actually made by the claimant, they were made by someone else. And we see that, how that's carried through, if we turn to paragraph 43 of the amended particulars of claim. And this is where we see first, upon execution of the SPA, the claimant directed Sajid SABOOWALA as his agent to carry out the due diligence and to facilitate the outstanding payments of the purchase price and any other payments as required. So that's the basis upon which Sajid SABOOWALA, as his agent, was making these payments. And then at paragraph 51, we set out, it is set out, how the payments of the 6.85 million were made pursuant to this arrangement. And it says, initially the claimant did so by means of various payments effected by Sajid SABOOWALA through Farmex or personally on the claimant's behalf, pursuant to the arrangement described at paragraph 14 and 43. There is simply absolutely no doubt as to how this claim is put in this particular claim, as to how the payments were effected on the claimant's behalf. There is equally no doubt in circumstances where agency is pleaded as to the basis upon which the claimant is entitled to claim these sums due under pursuant to these particulars of claim. And it should be added to that that in paragraph 54, we see how, in any event, 3 million of the total 6.85 million claimed were in fact made by the claimant himself. So to the extent that their argument in relation to whether payments are affected by Farmex or claimant or or Sajid SABOOWALA, in any event, that aspect of their argument doesn't work in relation to at least 3 million of the sums claimed. But in any event, it is simply an attempt by the defendants to obscure the position in a way on the basis simply of Deputy Chief Justice Steele's confusion on the basis of the earlier pleading. But the point is now, we're not in that position. The way in which the claim is put is abundantly clear from the terms of the particulars of claim. Now, not only that, but the basis upon which Sajid SABOOWALA entered into that arrangement is set out in evidence by a sworn witness statement by Sajid SABOOWALA himself. So it's, and I'll take you to that in fact, it's at page 261 of the bundle. My learned friend didn't take you to this paragraph. It's paragraph 17. By having set out the background, he explains the arrangement between the claimant and himself as to how Pharmax would affect payments on the claimant's behalf in relation to the SPA. It's simply the same way in which they made payment in relation to the purchase price, and it's simply reflected here. Now, the artificial criticism that somehow there needs to be documentary evidence of this arrangement is completely misconceived in my submission. The claimant is not making a claim against somebody on the basis of this arrangement between the claimant and Sajid SABOOWALA. The claim is against a third party, it's against the defendants here. As it is clear before the court now, that as far as how they arrange themselves between themselves, there's no doubt as to who is entitled to bring the claim. Sajid SABOOWALA say, it's not my claim, it's the claimant's, and the claimant says, it's my claim. There's simply no conflict there. The court can take comfort that there is going to be no suggestion of a second claim being brought by some other party, because both parties accept that the person who is entitled to the benefit of recovery of these sums is, in fact, the claimant. And that's a position that's changed since what was faced by Deputy Chief Justice Steele, because there was a reference in the pleading, incorrectly, as it would now appear from the revised pleading, to a loan to the claimant. Now, that isn't how it's put. That isn't the case being brought. Now, no doubt the defendants at trial will be able to refer to the reference to a loan in cross-examination and take the witnesses uphill and down dale in relation to that and suggest that somehow these payments weren't made in the way that they pleaded. But there's no problem with the way in which it's pleaded, or indeed the evidence supporting it. I would also draw your attention to one aspect of my own submission that was incorrect in relation to the statement that there was no evidence of repayment by the claimant. In fact, there is contemporaneous documentary evidence of repayment at pages 392 to 397 of the bundle, where we see the cheques made by the claimant to Sajid SABOOWALA, repaying the 6 million. So it's simply not right to say there's no evidence of repayment. How has your Excellency managed to find this reference? 392 to 397.
The checks, you mean?
Yes, exactly. So we see there payments to Pharmex made by ILYAS, GAFFAR, SABOOWALA, and then a statement of account as well. So that submission simply goes nowhere. It should also be mentioned that in relation to what was taking place in the Dubai courts, as my friend correctly said, there's no proceedings ongoing there. To the extent that there were some proceedings there, they have either been reached a conclusion or been discontinued. There's no suggestion of any double counting. There's no suggestion that any claim for amounts in the Dubai courts includes claims brought here. And if the defendants wanted to contend for that, they could put in evidence to that effect, and they've obviously not done so. So that's what I have to say in relation to the red herring of the farmers or the loan. Turning back to the question, the defendant's overall submission. In my submission, it's simply an attempt to sort of dress up an argument about contractual construction as some sort of jurisdiction dispute. That is simply a mischaracterisation of the position we're in. It may well be the case that were the claimant's construction of the contract not to find favour at trial, that it would turn out the fact that, pursuant to the jurisdiction clause, the court wouldn't have had jurisdiction to hear the claim. But that risk is a risk taken by the claimant. If at the end of all of this, it is found that the sums weren't brought pursuant to the payments weren't made pursuant to the contract, and therefore they're not entitled to repayment pursuant to Clause 5 or Clause 3(6), then that aspect of the claim would fail. But that's no reason to shut it out at this stage, and there's a reason why not to do so, not least because of the approach that the court must take and is obliged to take by binding authority in relation to contractual construction. And if I could take you in relation to this to my learned friend's skeleton argument at paragraph. Where is the skeleton? You'll see at paragraph 35. This is where my learned friend.
Yes.
38, in fact, of the skeleton argument talks about contractual interpretation and the relevant legal principles relevant to contractual interpretation. See at footnote 13, a reference is made to Appendix A to the skeleton, where a short note of the application of these principles under English law. If we turn to Appendix A, my learned friend sets out general points of construction, and A1 explains that the approach is identifying the intention of the contracting parties is an objective test. The court is concerned to identify the intention of the parties by reference to what a reasonable person, having all the background knowledge which would have been available to the parties, would have understood them to be using the language in the contract to mean. The point here is that in order to make a proper judgment as to contractual construction, the court must have the benefit of witness evidence as to the relevant background knowledge. It can't simply look at the document in isolation on the basis of submissions by my learned friend as to what the intention of the parties was. This is a complex question that requires evidence, and in those circumstances, on that basis alone, the court shouldn't conclude there's no real prospects of success in relation to the claim, because it's quite clear by the complicated submissions that were made by my learned friend that this is a matter that is ripe for examination at trial with reference to the relevant background as to what the parties intended at the time. It's right, it's not a subjective question, but when applying the objective test, what a reasonable person would do, we need to know what the background was that everyone was operating when they entered into the SPA. I'd also just draw your Excellency's attention to paragraph A7, where reference is made to the implication of terms. Now, this is a well-established mechanism by which the court can imply terms into a contract if the meaning is not clear. And it's submitted that the court should do so in circumstances where the court is seeking to render that meaning clearer, and also the terms to be implied should reflect the party's presumed intentions. Well, the party's presumed intentions can also only be ascertained by having proper evidence as to what the relevant background was at the time. So it's not right to say that the reference to an implied term in a particular claim is somehow some exceptional approach. It's a common canon of construction as a matter of English law, as reflected in the authority that my learned friend took you to, and this is the Damat and Ward case. And my learned friend, I don't know whether you have that sort of hand, refers to paragraphs 81 to 82, where the court adopts some of the principles from English law. For present purposes, what I would like to draw your Lordship's attention to is paragraph 84, which my learned friend didn't, she referred to, didn't read out in full, the Rainy Sky judgment, where Lord Clark said, the language used by the parties will often have more than one potential meaning. I would accept the submission made on behalf of the appellants. The exercise of construction is essentially one unitary exercise in which the court must consider the language used and ascertain what a reasonable person, that is a person who has all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of contract, would have understood the parties to have meant. In doing so, the court must have regard to all the relevant surrounding circumstances. In my submission, the court simply, at this interlocutory stage, without the benefit of evidence, disclosure, or evidence, is just simply not in a position to conduct that evidence on the basis of the submissions that have been put to you today in relation to construction. Now, it's in my submission overwhelmingly clear that the contention put forward by the claimant as to the construction of the contract and in relation to the reimbursement of expenses to ensure that the claimant is not out of pocket should the claimant proceed is an interpretation of the contract that has a real prospect of success and merits being aired at a full trial where the court will be in a position to make that judgment. As to the detailed submissions in relation to construction, now no doubt there would be proper submissions to make at trial, and that's the proper basis for them to be made. But to the extent they are made now, firstly, my learned friend seeks to characterise the way in which the claim is put as importing some sort of, or the necessary importation of some sort of obligation upon the claimant to pay for various things. Now, that is one way in which the claim is put, but if we turn up paragraph 38 of the re-amended particulars of claim at page 22 of the bundle, we'll see quite clearly that the claimant's claim does not rise or fall, or stand or fall, on the basis of whether or not there is an obligation under the SPA. What in fact is said is that there is, pursuant to clauses 2.6 and or 3.17 and or otherwise pursuant to a term implied into the SPA as a matter of business efficacy and or because of sole business. From the 1st of January 2016, the claimant was obliged and or expected. That's the way I put it to you this morning. And or expected to make payments on RAG's behalf and or otherwise inject funds into him. That is there was an expectation in relation to, under the contract, that payments would be made for routine business activities, as we've seen reference to throughout the SPA, and that expenses would be incurred, again as we've seen reference throughout the SPA, by the claimant when he has the single management of the company pending completion, and that they would be reimbursed at the end. Without that construction, why would the contract refer to the reimbursement of expenses? For example, when we in clause 2.4, when we are talking about the return of trademarks or vehicles, and the only basis upon which they would be returned is if all expenses are paid back, are repaid in full, and loss of profits and all the other things that were mentioned in clause 2.4. But otherwise, there would just simply be no point for them. But if the claimant is wrong about his construction of this aspect of the contract, then at trial, that is, then the claimant bears that risk. The claim will be proceeding anyway in relation to all the other reliefs sought. It would obviously be inappropriate to lop off this part of the claim if at that stage the claimant is unsuccessful, then so be it. But the point is to shut him out from putting forward the evidence that would make that construction of the contract render that the most acceptable to the court would be unfair and inappropriate at this stage. As to the subsidiary submission that it is trite law that a warranty only applies to a warranty period, the court should also always be cautious when a counsel refers to trite law without reference to authority, particularly in circumstances whether a term is a warranty or some other type of term or obligation in a contract is a matter of substance, not of form. And ironically, my learned friend, in arguing for her construction of clause 316, in fact seems to go into implying a term for herself, that 316 is somehow only applicable to a warranty period. Obviously, you were not taken, Your Excellency was not taken to any provision in the agreement in relation to any warranty period as to when these terms are applicable for. In fact, this aspect of clause 316 seems to be a freestanding obligation to repay expenses. And in my submission, that is the appropriate construction of it, and the court shouldn't be guided by whether it happens to fall under a title saying representation of warranty or not. But in any event, there are obviously matters to be dealt with at trial. So that deals with the questions in relation to construction. As to jurisdiction, I note my learned friend says that clearly if the claim arises out of the contract, the DIC courts will have jurisdiction. Well, Your Excellency will note that the principal basis upon which the claim is made is that it does arise out of the contract. So Your Excellency should have no fear in allowing it to proceed, because that is the basis upon which it's made, and that's the basis upon which the construction of the relevant clauses in the contract is put forward. My learned friend referred to claims in relation to the administration of the company or the corporate governance of the company, etc. But they're just simply red herrings. They're not relevant. They're not being made here. The claims are very clear, and they're in relation to repayment of expenses and all the other ones made for breach of contract. I would also point out, and I just take my learned friend says that somehow claims in restitution and breach of trust wouldn't fall within the scope of this clause. Well, in the very authority that she relies upon, the ILYAS claim, it seems, I know she pushed this submission very far, but it seems that it's at tab 5 of the defendant's authorities. If we pick it up at paragraph 64 and following.
Reading from where?
Paragraph 64 and following of tab 5 of my learned friend's authorities. So it's page 1066 of the internal.
Actually,
sorry, it's
on the defendant.
The defendant's authority.
There's no tabs. A new bundle just has tab.
It's not in the video.
It's not under the little tab, so
Sort of halfway through.
and it's sort of halfway through. I mean,
Okay. The case name is?
so the case name is Alliance and Aquanta. It's quite substantial in the middle of the thing. You might see it at the top of the bundle. If you look at the top, it's in there. There's a heading saying Alliance.
I got it.
Oh, you got it. So paragraph 64 of that is page 1066. Apologies for the bundle.
Our apologies, yes.
Okay. The page will be on the
top left,
right side, top right.
Top
Okay.
left, 1066.
1066.
So I'm simply referring to this was a question in relation to jurisdiction. I'm referring to this, and I'm not going into detail in relation to precedent. It's an authority that's relied upon by my learned friend. But at paragraph 64, Lord Justice Tomlinson refers to various cases referred to by counsel, by Mr. Toledano, and describes their effect in this summary. because of time, I'm not going to go into it. It's quite a complicated case. I'm not going to go through all the details.
Keep it for reading. So.
But the first case that was referred to was Albon and Nazar, where overpayments were made by the claimant in performance of an agency agreement between C and D, which overpayments C claimed in restitution as money paid under a misstated fact. C applied for permission to serve ample jurisdiction, describing this as a claim made in respect of the agency contract. The argument for J was whether a claim in respect of a contract must be a contractual claim. And then the judge's judgment is set out and explains that, but in my judgment, claims under Gateway 6.25, i.e. service out, are not confined to claims arising under a contract. It extends to claims made in respect of a contract. And the formula in respect of, tested by reference to English law, is wider than under a contract. See, accordingly, the formula of words in C+6 in respect of a contract does not require the claim arises under a contract. It requires only that the claim relates to or is connected with the contract. That's the clear and unambiguous meaning of the words used. And then it goes on, the claim there arose out of the contract which D was a party. My point is only this, that it's not right to simply say on the construction of clause 8 of the jurisdiction agreement, jurisdiction clause 8 of the SPA, it's simply not right to say that as a matter of course a claim for restitution doesn't fall within that, that description there. In fact, there's authority here with a slightly different wording when we're talking about in respect of, instead of in relation to this agreement in any way. If I just pick up the actual, Your Lordship will, Your Excellency will remember the actual formulation, which is this agreement is between the parties of the Westminster. However, if any differences or disputes arise in relation to this agreement in any manner. Now, in my submission, that's wide, equally as wide, if not wider, than in respect of a contract, which clearly here includes a claim for restitution. Similarly, paragraph 66, reference is made to a claim to a case Cherney and Deripaska, where the Court of Appeal held that the in respect of the contract gateway is wide enough to encompass a claim based on rights said to arise out of a contract, even if those rights are of a proprietary nature and include allegations of constructive trust. Again, it's simply not right to say that claims for breach of trust, which is here quis trust, are not necessarily included within the provisions of clause 8 of the contract. So to the extent that any argument is made in relation to those as a matter of jurisdiction, in my submission, that's without foundation. There is a basis for saying the court has jurisdiction to hear those claims. So far as the criticisms of the original particulars of claim are concerned, in relation to how paragraph 36 referred to 6.8 million, and then the claim brought in paragraph 61, the original particulars of claim in August 2017. Obviously, at that stage, the claimant was seeking specific performance, i.e. completion of the contract. So it's perhaps understandable why the focus was not in relation to repayment of expenses. It's only when you get to the amended particulars of claim that the alternative claim for damages and for repayment of those sums comes into sharp focus. That's why I use the word that paragraph 36 and 61 heralded this claim. There's a logic to it. It's not simply a flaw in the way in which it was put. Now, as to the new pleading, and this is probably, I think, my last submission, the draft re-amended pleading, my learned friend seems to switch between saying it's unrecognisable from the previous pleading or the same. She can't have it both ways in my submission. In my submission, it's not a excessively long document. It's complicated factual matters that needed to be dealt with, and it's been dealt with in a logical fashion. When my learned friend attempted to submit that there were aspects of it that were irrelevant to the claim, it's notable that she didn't actually refer to any specific paragraphs, but simply made a general submission. If, when Your Excellency has a chance to consider this matter, in reviewing the particular statement, I would respectfully submit that Your Excellency will see why those paragraphs have been included in order to make good the claim, particularly in light of the criticisms that were made by Deputy Chief Justice Steele, where he very clearly said that he wanted the pleading to be properly particularised, supported by the appropriate evidentiary material. In my submission, that is exactly what has been done now. In relation to the final point, my Manifronis points to whether the Quisco's trust claims made good on the evidence she gave in her sketch argument, I would simply invite the court to read the relevant paragraphs of Bellis and Challoner that are referred to, and would submit on the basis of that, as paragraph 54 of that authority, submit on the basis of that it is a properly pleaded claim, and the court has the basis upon which to conclude that the payments were made subject to a Quisco's resulting trust, and to the extent that needs to be made in evidence, it will be. Unless there's anything further. The final aspect in relation to costs. Obviously, Your Excellency will be aware that in the draft order, provision is made for the payment of the defendant's reasonable costs occasioned by any amendments needed to be made, in line with the usual order. And similarly, in relation to costs, I don't know how Your Excellency wants to proceed. But
I think the way which I'm going to deal with the cost, let's determine your application first, then, as Ms. Bushra mentioned earlier, by further written submission and regard the cost.
Excellent.
Yeah.
Unless there's anything further,
no.
That concludes my submission.
Thank you. It's clear.
Your Excellency, ordinarily I won't have a right to reply, but there is one point that I'd like to just address to you on, and that is this. My learned friend says that the 6.8 million, if it's the amendments relating to the repayment of the 6.8 million, if that is allowed, then that's a matter for trial, and that's a risk taken by the claimant, and the claimant will bear that risk if the claim fails. I say that's not what the test requires you to consider, and what it requires you to consider is prejudice to a party, and the real prejudice of allowing those amendments in to the defendant will be that it will be faced with the cost of defending an unmeritorious claim, which is doomed to fail, particularly in circumstances when it hasn't had the opportunity to contest jurisdiction. So, therefore, there's real prejudice caused to the defendant by allowing the amendment. So I'll leave that submission there in response.
I'm not sure whether these are properly matters for a rejoinder. If there are new matters arising from my submission, then obviously I would understand. But my letter seems to be repeating points that she's made in her submission. I just make that observation.
Noted. Yeah.
I'm grateful for the opportunity. Your Excellency, I don't have anything further to add.
Oh.
Thank you.
Thank you for both of you. I believe by next week I will hand down my judgment, and as I said, I deal with the application, then further submission and regard the cost.
Grateful for that direction.
Thank you.
And we hope you feel better. Your
Thank you.
Excellency.
Thank you for allowing us the time this afternoon.
That's okay. No problem. All of us have justice here.
Absolutely.